For Deputy Chief Justice Raymond Zondo to give an update on the progress made in appointing key personnel to the Commission of Inquiry looking into state capture allegations. Former Eskom Board Chairperson Ben Ngubane expected to give evidence to the parliamentary inquiry into Eskom. And the Supreme Court of Appeal in Bloemfontein will hear the matter involving the future of two high-ranking NPA officials. Australian batsman David Warner and South Africa's Quinton de Kock have been charged by the International Cricket Council for an incident in the players' tunnel during the first test. Very good morning to you. Just gone 9 o'clock, coming to you live from Johannesburg. This is Newsroom. I'm Shante Yankees. Thank you very much for joining me this morning. A lot coming up between now and 12 p.m. Live coverage as the NPA and the Hawks give Parliament an update on the state capture inquiry. We also go live to Cape Town, where the 17th World Conference on Tobacco Health is also being held. These and more top stories coming up. First up, let's have a look at your lead story. The top story: Deputy Chief Justice Raymond Zondo will brief the media later this afternoon on the latest regarding the state capture inquiry. Zondo is expected to reveal what progress has been made in appointing key personnel for Commission of Inquiry. Former President Jacob Zuma's terms of reference to the inquiry state that the Commission should also investigate all forms of government corruption, including allegations against him, his cabinet ministers, the Gupta family and state-owned entities. The inquiry is part of recommendations by former Public Protector Thuli Madonsela in her state capture report. Madonsela recommended that the Commission be given 180 days to complete its work and 30 days to report back on its investigation and recommendations. Former Eskom Board Chairperson Ben Ngubane will give evidence in the parliamentary inquiry into Eskom this morning. Several reports, including the leaked Gupta emails, have suggested that Ngubane facilitated the Gupta family capture of Eskom. Allegations Ngubane will have to clarify include an accusation by former Mineral Resources Minister Ngoako Ramatlori that he and former Eskom CEO Brian Molefe tried to pressure him into blackmailing mining giant Glencore into selling its Optimum mine to Gupta-owned to get resources. It is also alleged that Gupta associates had drafted the first speech Ngubane made when he was the acting chairperson. Well, this was the speech in which he announced the departure of his predecessor, Zolo Tsotsi. Ngubane resigned as Eskom board chairperson in June last year, amid reports that his passport was forwarded to Rajesh Gupta in October of 2013, along with quotes for a charter flight to travel to the Central African Republic. Ngubane has denied traveling to the Central African Republic at the time. Well, SABC News can now confirm that yesterday's raids at the Gupta residences in India were not just limited to their hometown of Saharanpur. Simultaneous raids also took place at Gupta offices and homes in New Delhi and Dehradun. Income tax officials are still not divulging the reason for the raid, but we can confirm that officials have seized several documents, computers, as well as hard drives. SABC News can also confirm that along with the income tax officials, a police team, a team of enforcement directorate officials were also part of the raid. Local reports coming in from Saharanpur allege that the officials are trying to identify a possible link between the probe against the Guptas in South Africa and the investments that they have made in Saharanpur over the last 3 to 4 years. For more on this, let's cross live to our Indian correspondent, Neha Punya, who is coming to us live from India. Very good morning to you, Neha. Essentially, what is the latest on the raids with regards to the Gupta residences in India?
A lot more details, Shantella, coming to light now about the raid that took place from early Tuesday morning local time. What I am picking up is that raid continued into the late hours of Tuesday, and like you just said, it wasn't just limited to income tax officials. We're now learning that enforcement directorate officials were also part of that raid. Now, this is crucial because enforcement directorate is one of the top agencies in India has probed financial crimes and looks into possible money laundering. And that is raising several questions. Why were they now looking into the Gupta properties and that of their associates? Locals are speculating this has something to do with the investments the Guptas have been making in Sahara. Murmurs on the ground about South Africa possibly having brought into Sahara and then invested in infrastructure and other projects there. And of course, all of this is still under the realm of investigation. So we will find out more. The officials make the reason for the raid now.
Are there any other reasons as to why the officials are actually raiding the residences and the businesses?
Shraddha, like I said, it's not clear yet because this is usually how income tax raids are conducted in India. Once officials and the team reach the place that they're going to search, they seal off the entire premises, and they don't divulge details in order to ensure the probe doesn't get compromised. That's what we're seeing right now, and what we can infer is the manner from which the raid has been conducted, the fact that documents have been seized, the fact that computers and hard drives have been taken into possession and are now going to be searched. All of this points to some sort of attempt to find out if there's any kind of link between the South African probe against the Gupta brothers and the kind of money they brought into India over the last few years.
Definitely. Speaking of South Africa, we do know that the Gupta family now also have problems with their South African citizenship. Can you talk to us about the issues surrounding that?
This is something that I've raised with the Indian government on various occasions, and every time the issue of the Gupta brothers is cropped up, the Indian government has had only one thing to say: they are no longer Indian citizens. In fact, going by what we're picking up from officials here, only Ajay Gupta, he's the only member of the Gupta family who has continued to hold on to his Indian passport. So as far as the Indian government is concerned, Atul Gupta and Tony Gupta gave up their Indian citizenship many, many years ago. So that's what the Indian government has to say.
And at this point in time, can you give the whereabouts? Can you confirm if the Gupta family or any one of the brothers are still in India at this point in time?
The Gupta brothers were spotted in India last month, around the same time that the probe and the raid against them was taking place in Johannesburg. At the time that their palatial home was raided by members of the Hawk, they were actually in Saharanpur, then they went to Agra and to another city of Dehradun, which is very close to the national capital of New Delhi. In all of these cities, they met family friends, they met relatives, attended a wedding, also stayed at their palatial home in Dehradun, but they left India soon after. Now, SABC traveled to the hometown of the Guptas last week. We were in Saharanpur and we spoke to their family, friends and locals, and they told us that as far as they know, the Guptas are currently in Dubai. That's where they're now trying to move their business and their family to. And the rumor on the ground in Saharanpur is that eventually the Guptas are going to move their entire empire to Dubai and operate from there.
Definitely. Thank you very much for giving us an update on that. Of course, the raids around the Gupta businesses and residents in India. That was our correspondent, Neha Punya, who was giving us a live update from India, as well as the alleged whereabouts of the Gupta, ending off that they are possibly in Dubai. Having a look at some other news stories this morning, Home Affairs Minister Malusi Gigaba has warned the Gupta family members that his department will revoke their documentation if they are convicted of a crime in South Africa. Well, yesterday, Gigaba addressed the media in Parliament, during which he backtracked on whether the Gupta brothers were in fact South African citizens.
If there was any intention on our part to favor this family and grant them citizenship, regardless of what the law stipulates, we would not have asked them to renounce Indian citizenship. We would simply have gone ahead to say, ignore the South African law, regardless of what our law says, provide them citizenship and carry on. And that is why we put it to them to renounce Indian citizenship, at which point, when Mr. Ajay Gupta refused to, we then told him that you therefore cannot be granted South African citizenship. It's still an accusation. We don't know whether you may still be found not guilty and win your case in court, in which case we would be accused of having prejudged the matter, jumped the gun, prejudiced you and be found to have acted improperly. So we wait. At times it can be a complete irritation.
Well, the Supreme Court of Appeal in Bloemfontein will today hear the matter involving the future of two high-ranking NPA officials. A senior NPA executive say the High Court in Pretoria misdirected itself when it ordered the pair to be struck off the role of advocates. The Deputy National Director of Public Prosecutions, Advocate Nomgcobo Jiba, and Specialized Commercial Crimes Unit Head Lawrence Mrebi are challenging the order in the Supreme Court.
Determined to hold on to their jobs, Jiba and Mkhwebi are taking their fight to the SCA. The General Counsel of the Bar approached the High Court in Pretoria to declare them unfit to practice as lawyers. The Bar acts as the regulatory body of practicing advocates. Jiba and Mkhwebi were rebuked following the withdrawal of, among others, murder and corruption charges against former police crime intelligence head Richard Mdluli. Lobby group Freedom Under Law applied to review and set aside the decision to withdraw the charges against Mdluli.
If then the allegations that one is involved in fraud and perjury matters, then that on its own would also have an impact on the requirement of being a fit and proper person. And that on its own would also have to necessitate the council to be an application for a person to be struck or be removed as a practicing advocate or an attorney.
In papers before the SCA, Jiba and Mkhwebi argued that the High Court order was harsh and disproportionate to the conduct. Jiba has denied any involvement in the withdrawal of the Mdluli charges. Jiba and Mkhwebi have been placed on special leave pending finalization of the case. Tebohole Tsaba, SABC News, Bloemfontein.
Well, Health Minister Aaron Motsoaledi is today launching the 17th World Conference on Tobacco or Health in Cape Town. More than 200 million rand will be spent to launch a watchdog to detect and expose deceptive practices by the tobacco industry. Philanthropist Michael Bloomberg, and also an ambassador for the World Health Organization, plans to counter the industry's influence by publishing reports detailing pro-smoking activities and tactics. It will also support non-profit organizations and government to resist interference from the tobacco industry. More on the conference, we will be joined by Mbalenhle Mthethwa. Of course, she'll be giving us all the updates. Mbalenhle, a very good morning to you. What is the 17th World Conference on Tobacco and Health taking place in Cape Town? What is it all about this morning?
Hi, Shante. What's happening today in Cape Town is that we've got world leaders and civil societies, UN representatives meeting to improve tobacco control measures. And what they want to do is to actually increase tobacco taxes, ban the promotion of tobacco products, and as well as, this year the theme, what's happening is that the theme is uniting the world for a tobacco-free generation. So this is in an effort to prevent millions of deaths from tobacco-related illnesses and diseases. Health Minister Dr. Aaron Motsoaledi spoke out against the tobacco industry just not so long ago in a press briefing that he had, and he said that tobacco companies are profit-driven, and then he said tobacco is not adding any value at all to society. And what he's also said that, he's going to be working hard with regards to adding e-cigarettes, with regards to preventions of prohibiting advertising. But yesterday when he spoke, he was at the launch of a knowledge tobacco taxation, which is actually being launched in partnership with the Sefako Makhatu University. And with me to speak to me more about this is Prof. Ayo Yusuf. Good afternoon. Good morning, rather. How are you, sir?
Good morning.
It's a pleasure to have you with us. Tell us more about this this knowledge hub.
Right. Perhaps just to put it in perspective, yesterday the minister launched two centers of excellence in South Africa. One was the knowledge hub to UCity that's going to be focusing on the economics of tobacco, which includes issues around illicit trade, what the price effects when you increase prices of cigarettes would be as a policy. And the second one was launched is looking at tobacco industry monitoring, which is going to be based at Sefako Makhatu Health Sciences University, where I am based. So this center is going to be collating from different places in Africa the activities of tobacco industry, as we know, they would fight to make sure that all tobacco policies don't work. So in order to emphasize some of those, we need to kind of monitor what they do around the continent, because they tend to do the same thing. So that if you know what is happening in Senegal, you can prevent it from happening in South Africa, for example, and make sure that they do not interfere with government policy process.
Okay. Illicit tobacco trade. How big is this industry?
Well, the illicit tobacco trade, it's been something that's been said to be big at every time. Industry will say 10 years ago, illicit tobacco trade has increased to 20%. 10 years after, they say it's increased to 20%. It is not true. The extent of illicit trade is not as what the industry would like to make it out to be, but it is there. But the problem is not because of the policy to increase tobacco taxes. This is what the industry would like us to believe. It's because of the corruption that is happening and lack of enforcement. So not increasing prices does not get rid of illicit trade. As we know, it's already happening. So we need to have a stronger law enforcement, and that's why it was said yesterday that the South African government should sign the illicit trade protocol with the WHO, which will see a particular way to track cigarettes, so that if it's going around, because illicit trade is about cigarettes that you don't pay taxes on. So if there's a tax stamp, you know which ones you've paid taxes on, and you know which ones have not paid taxes on. So South African government needs to sign the illicit trade protocol to follow this particular protocol and to prevent illicit trade. Okay.
Now we know the UN is here, civil society groups are here, but are the tobacco industries represented at this conference?
They're not supposed to be, but we know the way they work. They find ways to get into these conferences. And I think this is also one of those key importance of having a center like the Tobacco Industry Monitoring, to understand exactly their modus operandi. In fact, they use credible professors these days to actually do the work. So you can find a professor here who's actually paid indirectly by tobacco industry, and they communicate with them, they find their ways into meetings that's not supposed to be. So this meeting itself, as the chair of the scientific committee of this meeting, we do not accept anyone who's affiliated with the industry at the meeting. So you're supposed to have declared at the time of registration if you have any affiliation with tobacco industry, and you're told you are not welcome. However, obviously, if people are not ethical and don't declare this, they will find themselves at the meeting. But we don't care. The science will be spoken. This is so important. This is the first time in 50 years of this meeting that we are having it in Africa, and to have 2 hubs in Africa, 2 of the 7 that is around the world in South Africa, it's quite significant.
Thank you so much for your time. Thank you very much. Shante, it's over to you in studio.
Thank you very much, Mbalenhle, taking us through what has been transpiring out of that 17th World Conference there for Tobacco and World Health. Well, moving on, the National Prosecuting Authority and the Hawks are briefing a joint committee of the police and justice on progress as well as challenges regarding the prosecution of state capture cases. Let's cross live.
The investigating team has inter alia done the following. I beg your pardon. The joint teams engaged in no less than 24 formal meetings. They received 19 dockets or inquiries relating to various allegations. They received 7 forensic or investigative reports commissioned by National Treasury or civil society organizations. They issued 373 Section 205 subpoenas. They drafted and submitted requests for mutual legal assistance to 8 countries and directly engaged with prosecuting authorities in 7 of these countries. The work of the team must be viewed against the fact that cases of this nature are extremely complex, and like the arms deal prosecutions, may take several years to investigate and to prosecute on a running court roll. The asset forfeiture conducted preliminary assessments of the various reported matters and incidences. They identified 17 cases with asset forfeiture potential to the collective value of 50 billion rand. Of course, these are to be dealt with in terms of Chapter 5 and Chapter 6 of the Prevention of Organised Crime Act. To date, the Asset Forfeiture Unit has obtained 2 preservation orders, an amount of 1.6 billion rand in respect of the McKinsey and Trillion agreement, and 228 million rand in respect of the Estina matters. Of course, there are a number of other matters that are in the process of being finalized, so we can expect these applications to be brought within weeks. In fact, some of them should have been brought already. I want to speak about the Estina matter. The Estina leg was prioritized and was first referred to the National Prosecuting Authority on the 18th of August last year. In the space of the past 7 months, the NPA team of Asset Forfeiture Unit specialists and the prosecutors were able to ensure that the investigations by the DPCI were fast-tracked so that a preservation application could be brought, that search and seizure operations could be embarked upon, and arrests of some of the accused could be effected. The investigations are far advanced, with search and seizures having been conducted and the arrests having been effected against 3 government officials, the director of Estina, and 3 directors of companies that received the proceeds of crime. The latter companies and directors were charged with offences of theft, money laundering, and contraventions of the Companies Act. There, however, remain a few outstanding aspects. It is for this reason that the matter has been postponed to the 17th of August 2018 for further investigations. I want to deal with the responses to the issues raised by the acting head of the DPCI. After General Matakata's appearance before the Portfolio Committee on Police last week, I requested a comprehensive report and briefing from Advocate Governor on the Estina matter and on the remarks made by General Matakata to the Portfolio Committee on Police, insofar as it relates to the NPA. On Monday, 5 February, I was provided with a report on a factual account on the NPA's engagement with the DPCI based on inter alia notes kept by the head of the SCCU in her office file, reports received, email correspondence, entries in the investigation diary of the police docket, and briefings by the prosecuting and investigating teams. I do not intend to traverse all the engagements and interactions between the NPA and the DPCI in relation to all state of capture investigations and the Estina matter, but only that which I deem is relevant for today's briefing. Now, General Matakata and I have always enjoyed a very collegial and professional working relationship from the commencement of her stint as head of the DPCI. Of course, we would telephonically communicate with each other at any time convenient to the both of us, and we would meet regularly on various issues impacting on our respective institutional, legal and constitutional responsibilities, even after hours and on weekends. A relationship that we still share and which I have no doubt will continue going forward. It is regrettable that General Matakata made some of the utterances to the Portfolio Committee on Police insofar as it relates to the NPA, as I believe and have been advised that she had been incorrectly informed and or advised. I also believe that the issues raised by General Matakata could easily have been resolved outside of the public fora directly between the two of us. This misinformation has incorrectly given the perception that the NPA and the DPCI and or the prosecuting team and the investigating team and or General Matakata and I are at loggerheads. This, I assure you, is entirely incorrect. We nevertheless dispute to the fullest the utterances made by General Matakata to the Portfolio Committee on Police on 28 February 2018, specifically insofar as it relates to the NPA. During the evening of 22 May 2017, General Matakata and I, whilst participating in another engagement, took the opportunity to also discuss the state of capture investigations. In this regard, we discussed consolidating all the matters under one investigating team. At the time, I had already constituted a prosecuting team. and of course that all the state of capture related investigations be subsequently submitted to the prosecuting team to provide the requisite guidance under the prosecutor guided investigations methodology. This was agreed upon. At the time, some of the matters were being investigated by the DPCI's serious economic offences. I pause to state, I think that is what they are titled, and some by the anti-corruption task team. By July 2017, all the matters had not been forwarded to the NPA as yet. Advocate Mzanyati, who's present today, the Deputy National Director of Public Prosecutions and Head of the National Prosecuting Services, to whom the head of the SECU reports, wrote to General Matakata on 7 July requesting the General's assistance in facilitating the referral of all matters relating to the state of capture allegations to the NPA. On the 2nd of August, Advocate Governor called a General Mononopi of the DPCI to inquire about the docket in the Estina matter. This was followed up by a meeting dated 3 August 2017. On the 8th of August, a meeting was held with 2 members of the DPCI investigation team and the NPA's head of the SECU and the head of operations of the asset forfeiture unit, where assistance was rendered in the signing of subpoenas in terms of Section 205 of the Criminal Procedure Act. On the 18th of August, the self-same members of the DPCI provided the docket to the NPA in respect of the Estina matter and 2 other related matters. At that stage, the A-clip of the docket, which ordinarily contains police witness statements and evidence, only went up to A5. On the 21st of August 2017, the NPA obtained National Treasury's reports in respect of the Estina matter and another matter, which I don't deem necessary to mention to this committee today, which reports were provided to both the investigating team and the prosecuting teams. On the 25th of August, the DPCI investigating team met with the NPA prosecuting and asset forfeiture teams. At that stage already, Advocate Governor alerted the joint teams of ensuring that their activities canvassed the flight risks that potential suspects presented. Advocate Governor further requested the joint team to fast-track the investigations and for a draft charge sheet to be available by November 2017. The team, however, expressed grave reservations about this being achievable in the light of the nature and the complexity of the investigation and the case. On Saturday, 26 August, I was briefed by the prosecuting and asset forfeiture unit teams on their strategies to preserve assets and to have matters enrolled expeditiously and to manage any potential flight risks. I was deeply concerned about the progress of the investigation into this matter and a number of other investigations, and had previously made specific recommendations to General Matakata during one of our many one-on-one engagements. I thus deemed it prudent to write to General Matakata on 1 September 2017, in which communication I inter alia conveyed the following: that I was deeply concerned about the lack of significant progress with investigations in respect of some very topical, high-profile, serious alleged corruption, fraud and financial mismanagement matters, some of which had previously been discussed between the 2 of us. I implored on General Matakata to assign additional resources and investigators to these matters. I advised that I was of the respectful view with which General Matakata was in agreement, that serious consideration be given to invoking the provisions of Section 17 capital D subsection 3 of the South African Police Service Act in some of these matters by requesting me to appoint a Director of Public Prosecutions or a Special Director as an investigating director to fast-track some of these investigations. Further, that in the event this is done, I will provide a favorable response thereto. I further alluded General Matakata to the provisions of Section 17 capital J subsection 1A of the South African Police Service Act, which provides for the establishment of an operational committee to be comprised of, inter alia, the head of the DPCI as its chairperson, the head of the Crime Intelligence Unit of the Police, the National Director of Public Prosecutions, the Directors General of Finance, Justice and Constitutional Development, State Security, Home Affairs, the head of the Financial Intelligence Center, and any other person the operational committee may require as determined by that committee. Subsection 2A of the SAPS Act obligates the operational committee to review, monitor, and facilitate the support and assistance by respective government departments and institutions to the DPCI, including the secondment of personnel to the DPCI, and to address problems that arise in respect of the rendering of such support and assistance to the DPCI. I apologize. Further, that since the DPCI is dedicated to prevent, investigate, and combat national priority offences, in particular serious organised and transnational crime, serious commercial crime and corruption, it requires the close cooperation of key stakeholders in the justice, crime prevention and security cluster. That notwithstanding the fact that the DPCI came into operation many years ago, the envisaged operational committee is yet to be established, and that I was confident that the establishment of the operational committee soonest would significantly impact positively on our collective endeavours and efforts to combat the scourge of the various serious crime typologies that have impacted negatively on our economy, the safety and security of our citizens, and the safety and security of our borders. I'd raised this concern with General Matakata by way of illustration, in that my concern was particularly highlighted at the time by the challenges we faced in combating money laundering, illicit financial flows, and terror financing, by the non-establishment of a counter-money laundering advisory council, which was a statutory requirement in terms of the Financial Intelligence Center Act when it came into operation on 1 February 2002. The council, to be constituted by many of the same persons who would constitute the DPCI Operational Committee, was obligated to advise the Minister of Finance on policies and best practices in identifying the proceeds of unlawful activities and in combating money laundering. It was further obligated to advise the Minister of Finance on the powers entrusted to the Minister in terms of that Act, and to advise the Financial Intelligence Center on the performance of its functions. Despite the significant importance of having to establish this council, various ministers of finance at the time did not deem it necessary to give effect to the statutory requirements. I further advised that these decisions had adverse consequences in the Republic's ability to combat money laundering, terror financing, and illicit financial flows, and that the FIC Act was amended earlier in 2017, with one of the most notable changes affected being the abolishment of the entire chapter providing for the Counter Money Laundering Advisory Council. I hence cautioned against a similar position than that which abolished the Counter Money Laundering Advisory Council. The Asset Forfeiture Unit and the SCCU teams were from the end of September bolstered by the appointment of 7 additional investigators from the DPCI. The police's financial investigations, FAFI, were also allocated 3 additional members. The core team of the investigators remained responsible, but now reported to Colonel Heap, who was assigned as the lead investigators on all these matters. The joint DPCI and NPA teams met again on 13, 27 and 29 September 2017, 16 and 31 October 2017, 8 and 21 November, and again on 7 December before breaking for the festive season. The next meeting was on 18 January 2018. It must be noted that the issues related to bail and the identification of suspects is recorded in the case investigation plans of September 2017. On 25 October, the prosecuting team was provided with a copy of the A-clip of the docket. At that stage, the statements and evidence filed in the docket had progressed to A35. The prosecuting team, however, noted that the scanned copy of the docket provided was incomplete and requested the investigators to be provided with the docket to physically go through the docket and compare what they had received via scanning. This was, however, only provided to the prosecuting team on 14 November 2017. On 8 November, the head of the SCCU was provided with a memorandum and a draft affidavit by Brigadier Basi of the DPCI and Colonel Heap for submission to General Matakata for the NPA's input. Brigadier Basi intimated that if the NPA was in agreement, then warrants of arrest would be issued for the identified suspects. In this regard, Advocate Governor advised Brigadier Basi on how the affidavit should be structured, as the draft omitted canvassing the charges of money laundering and the linkages to clearly establish the prima facie case, which was prerequisite at the time, along with the flight risk information. Advocate Governor further recommended that General Matakata and I be briefed in connection with the arrest of suspects of foreign descent identified as potential flight risks. On 14 November, Brigadier Basi advised Advocate Governor that General Matakata had informed Scopa that the investigation into the Estina matter had been finalized and the docket had been submitted to the NPA for decision. Brigadier Basi and Advocate Governor agreed at the time that the matter was not fully investigated. The prosecuting team further advised that it was not possible for the Estina docket to be submitted for decision, as there were substantial investigations that were still outstanding. A case investigation plan dated 8 November detailing the investigations outstanding was provided to Advocate Governor. The prosecuting team further advised that fast-tracking of the financial investigations was material to proving the theft and money laundering charges against the suspects of foreign descent, in respect of whom there were concerns of being a flight risk, so as to establish the prima facie evidence required. In December 2017, the prosecuting team received a draft financial report from the DPCI. The team raised concerns that the report could not be verified against the bank statements, in assisting them that a prima facie case had been made out, as it was not a product which could be relied on or presented in court. On 6 December, Advocate Governor met with Brigadier Bukaba and Colonel Heap, where she identified several material deficiencies which the prosecutors correctly observed would preclude same from being used at court. It further presented a challenge in that it did not provide the basis in the memorandum submitted by Brigadier Basi in respect of 4 suspects of foreign nationality. Brigadier Bukaba undertook to address the shortcomings and to ensure that these were rectified as soon as possible in the new year, as the designated DPCI member had already taken leave for the festive season. On 7 December, during a meeting with the prosecuting team and the DPCI investigators, the prosecuting team advised that they were of the view that a prima facie case could not be made out against the parties identified for the purposes of the theft and money laundering charges from the available evidence, especially without the case flow analysis. Accordingly, no warrants of arrest or affidavits had been prepared by the DPCI investigating team to be submitted to the prosecutors for consideration. This was accepted by all the parties, as it was both rational and reasonable. Advocate Governor once again raised the issue of flight risks, to which she and the DPCI investigators advised that monitoring of the suspects' movements were in place. It was jointly decided by both the prosecutors and investigators that the arrests would be targeted for early in 2018, in light of the fact that all the members were also on leave over that period. The prosecuting team was satisfied that the DPCI had put adequate measures in place to manage the flight risks suspects had presented. An updated case investigation plan, which once again highlighted that the DPCI investigators should work on the bail information, was provided to the DPCI investigators. This was required for the arrests of suspects and for their first appearances. The witness statements and evidence filed in the police docket now went up to A82. On 6 December, I was briefed on the matter, during which briefing I also raised the issue of arrests. I was advised that the prosecutors were not in a position to apply for warrants of arrest against the persons of foreign descent. On 11 December, the Minister of Justice and Correctional Services was briefed on the state of capture investigations. On 15 January, Advocate Governor requested Colonel Heap to provide feedback on the warrants of arrest and affidavits. On the 18th of January, during a case status meeting, the prosecutors were presented with an affidavit and applications for warrants of arrest for the very first time. The prosecuting team once again expressed their discomfort in certifying there was a prima facie case establishing the money laundering and theft charges. Brigadier Bukaba was requested to appoint another senior member to assist so as to fast-track the financial analysis within 2 weeks, as the prosecutors did not want this to impact on the charging of any of the suspects. The prosecutors further advised that the arrest affidavit was deficient, as it did not deal with the flight risks, and they had requested the investigators to address this important issue. Only on 23 January were the prosecutors provided with a copy of the affidavit to be used in the search and seizure operations. On the evening of 24 January, Brigadier Basi, Colonel Heap, and Advocate Governor briefed General Matakata and myself and Advocate Nzanyati on the search and seizure operations. At no stage during this meeting did General Matakata raise any of the concerns she had raised with the Portfolio Committee on Police a week ago. We were advised that the search and seizure operations would not be accompanied by simultaneous arrests, and that any arrests would be effected soon after the search and seizure operations and after the seized evidence had been evaluated. We were further advised that the reasons advanced for the arrests not being effected simultaneously was as a result of the bail information that was still outstanding, along with the financial analysis which was targeted to be completed within the time frame that had been provided, along with additional statements. This meeting was ideal for General Matakata to raise her concerns about the delays that she had uttered to the Portfolio Committee a week ago. It was not raised with me. On 25 January 2018, the search warrants were authorized by the magistrate in Bloemfontein and executed the very next day. On 27 January, the investigators obtained statements of beneficiaries, which was investigations that had been identified as being outstanding as far back as September 2017. On 31 January 2018, one of the prosecutors penned the nature of the amendments required for the affidavit for the application for the warrants of arrest, which was provided to the DPCI the same day. On 6 February 2018, the prosecutors met with the investigators and the financial analyst. The prosecutors, supported by one of the financial analysts, expressed reservations about signing off on the warrants without the financial investigations having been finalized. Advocate Governor obtained a copy of the docket during the evening of 7 February and perused same. It is only thereafter that members of the DPCI were advised that they could effect arrests at any stage where it is clear that a person is a flight risk. There was still a substantial amount of information required to be included in the affidavit. Advocate Governor provided guidance to Brigadier Basi thereon and requested the affidavits to be submitted to her by the Friday so that she may attend to the first appearances of the arrested suspects and accused by the Monday, 12 February. The affidavits were forwarded to Advocate Governor on 11 February 2018. Advocate Governor in turn provided an input via email on 12 February 2018 in which she recorded her concerns about the impact on the case as it relates to potential extraditions, and a joint decision was taken to focus on those suspects that the police had traced as being within the borders of the Republic. Brigadier Basi at that stage telephonically advised that some of the suspects had already left the country on or about 12 August 2018. That is approximately a week before the docket had been submitted to the National Prosecuting Authority. On 13 February, members of the prosecuting team met with the investigators and signed off on the warrants of arrest. Advocate Governor suggested that General Matakata and I be briefed on the arrest, but was advised that General Matakata had already been briefed, after which she subsequently briefed me. The arrests were effected the very next day on 14 February 2018 on the persons whom the investigating officers had established were still in the Republic. Brigadier Basi advised that Mr. A.J. Gupta was noted as being in the country when the warrant for his arrest was authorized, and that unfortunately Mr. A.J. Gupta could not be arrested as he purportedly fled while the arrests of others were effected at the Gupta residence in Saxon World. All those arrested appeared in court and were granted bail. The matter has now been postponed to 17 August 2018 for the finalization of the investigation. To answer your questions, was the investigation into the Estina matter concluded in November 2017? In other words, was a fully investigated docket submitted to the National Prosecuting Authority in November 2017? The answer is an emphatic no. That much is evidence from the facts which are presented today. Was the DPCI only given the go-ahead by the NPA team of prosecutors in February 2018, which resulted in the arrest? That is correct. The investigations were at a stage where a prima facie case had been made out against the individuals who were arrested and against those whom warrants of arrest were obtained. Did the DPCI express its concerns that matters were dragging? General Matakata did not raise this with me. In any event, it is clear that the NPA prosecutors did not drag their feet in this matter. Ordinarily, matters of this nature take an extremely long time to investigate, and sometimes even years to prosecute. The docket was only presented to the NPA in August 2017. In less than 7 months, the accused were brought before court. Did General Matakata take this up with both the former Minister of Police and I? I dispute that General Matakata took this up with me. In fact, I was completely surprised by the comments to the Portfolio Committee on the issues that we have addressed today and were addressed a week ago. Did the NPA hinder the work of the DPCI in not taking the matter to court expeditiously? We dispute this in the strongest sense that the NPA hindered the work of the DPCI in not taking the matter to court expeditiously. Decisions were taken jointly by the NPA prosecuting team and the DPCI investigating team. If the matter was not ripe for enrollment, surely the fault cannot be placed at the door of the National Prosecuting Authority. In other words, if the NPA is not satisfied that there's a prima facie case to enroll the matter, how can it be expected of the prosecutors to do so? Notwithstanding this, nothing precluded nor precludes the DPCI from arresting any suspect in any matter with or without a warrant. This they are aware of. Notwithstanding this, in such a situation, if the prosecution is not satisfied that a prima facie case has been made out, the matter would be removed from the court roll and a suspect and or accused will be released from custody. Are there cases, in some instances, where dockets have been at the NPA for a year for the NPA to take a decision? These have not been brought to my attention. I'm unaware of these, and I invite General Matakata to provide Advocate Mzanyati and I with a list of these cases to enable us to investigate these delays and to take the requisite action. My concluding remarks. It's regrettable that these issues found its way into the public fora prior to being addressed by General Matakata and I. The matter could have and should have been handled differently. We regard the DPCI as one of our critical partners in the fight against serious national and transnational crimes, financial crimes, maladministration, money laundering, corruption, and organized crime in all its forms and manifestations. We look forward to continue working closely with the DPCI and building on the already entrenched professional relationship, goodwill, and generally good relations between the two institutions, and in giving effect to the provisions of Section 41, subsection 1H of the Constitution. We'd like to thank the joint committees for inviting the National Prosecuting Authority to provide clarity on the issues which arose during the briefing by the DPCI to the Portfolio Committee on Police a week ago. Thank you.
Thank you, Advocate Abrams, for your presentation. We will now give an opportunity to not Advocate, but General Matakata. Yes, Joint Chair.
Just to also thank you for the eloquent presentation, and to say that we believe in leveling the playing field. In that regard, I'm just wondering whether you did share your presentation with General Matakata. I see that she's strenuously trying to take notes, and whether it would she would be able to do justice to what you have said, but just as an observation. But I think that in the light of what you said, to say you work together, you should have shared this with her so that she also prepare a response. But anyway, we are where we are. Co-chair, let's afford her an opportunity to respond.
Advocate Abrams, it's in your field referred to as right of replication, if I'm correct.
Quite correct, and I accept.
Right, thank you very much. The acting head of the DPCI, General Matakata, will give you also an opportunity to address the committee. Thank you very much.
Thanks, Chairs, and thanks to the briefing by Advocate Abrams. I think first it has to be clarified, because the presentation started with what was said in the Portfolio Committee on Police by myself, in that the work of the DPCI was hindered by the NPA. And I think this question was asked twice, and I expressly said the work of the DPCI was never hindered by the NPA, but gave context to maybe hindering in that context might be the time delay. If it was perceived like that there was a time delay of working out from the onset that the docket was provided up until the arrest of the suspects, that there was a hindering in that context of people taken to court, but not necessarily that NPA hindered the work of the DPCI. I just want to correct that, because it seems as if there's that understanding that I indicated that the work of the DPCI was hindered by NPA. I need to emphasize that. And also to indicate as well that from the presentation given, it is so that there is a working relationship between the DPCI and the NPA with prosecutors that have been allocated, and I did mention that the advocate did indicate and pronounce that there were prosecutors that were dedicated to the state of capture investigations. That is so. And the work has been going on regardless of when the docket was shared with the prosecutors for the first time. That is in August, as he expressly indicated. That the work has been going on, and that work is still continuing, because there's, as indicated, how many legs are there in terms of the work that still needs to be done. But I need to also, again, reflect and emphasize that from what has been going on and said about, and I think it comes out from the, probably from the presentation, that I have thrown Advocate Sean Abrams under the bus. And I think it is that context that is being misused in the public space, that he has been thrown under the bus. And even today, the agenda being given out there is that there's going to be a standoff. And I think if we can really understand that we are mandated both, and I'm also mandated by the Act, DPCI has to function in a multidisciplinary approach. We have to work with other government institutions, and DPCI has to work with prosecutors. There's no other way, because they must take matters to court, they must prosecute the matters to court. So therefore, I'm not sure if that context is being expressed in the public space, from just expressing in the last meeting that the docket was submitted in November, decisions were taken at some point in the 2018 financial year, should be perceived as if there's a standoff and there has been, I've thrown NDPP under the bus. And I don't think that is right, because there's a working relationship that is existing. In terms of the other matters that have been raised and the working relationship that existed, regardless of when the docket was submitted, I think it's going to put us in a situation where DPCI will say, we did this, we had these reservations, we submitted the docket and indicated that let us not rather work towards preferring all the charges. If you have to go to money laundering or racketeering, can't we focus on the other charges that we could before, because it's the same issues of some of these suspects would maybe leave the country. The concerns were raised obviously in the meetings. But from what has been raised by the NDPP, that there were those discussions between the teams, because remember, these were teams that were working together. And those issues might have been raised in those meetings, and taskings given back to the DPCI investigators and so on. And I think even the last meeting where we were to briefed in January, as referred by the NDPP, there was no indication that we'll have to wait until the financial analysis is correctly is done for us to proceed with money laundering or other charges. But we had agreed that we will go ahead and then have the people arrested, after we had agreed even to go to Frede and do a search and seizure operation. So at that point, there was no need in January, at that time when we were busy, that there was a complaint that needed to be laid at the time, because we agreed and we were briefed that let the team proceed, and therefore people might be arrested and so on, knowing what numbers of people were to be arrested and who all were to be arrested. So it's unfortunate some of these things are articulated and I've not been given the opportunity to also prepare. But I again say this shouldn't be seen as we're having a standoff, because we have work to do and we have to continue with the work that must be done. But if at any point, and I agree with the issues that might have been that were raised by the advocate in terms of even the operational committee that has to be established and so on. But I thought this would be an opportunity for us to get clarity, and I think he has given that clarity from the context of the NPA, why it is perceived that this matter was dragged if DPC had submitted the docket in November. So I would leave it.
Right, thank you for that input. I think it will also be advisable going forward, General, that you give us full response to the written input of Abrams, that we can study it as committees and then also take it further. But I think, Joint Chairperson, maybe we should go to questions to the members. We'll start on that side and we'll work through. Yeah, I'm recognizing all the members. Thank you very much. Honorable Molabatsi.
Thank you, Chairperson, and thank you for the briefing. General Matakata, you might have not said DPCI work is hindering, I mean your NPA work is hindering your work. But fact of the matter is justice delay is justice denied. Justice denied. It's justice delayed is justice. Yes, that one. That is my point. Now to advocate Abrams, the president of this country in his honor promised the citizens of this country that he's going to deal with corruption. And any action of delaying or procedures or submissions or what can be interpreted as a sabotage to the good work that he mentioned to the citizens of this country. What is your take on that one? Thanks, Chair.
Thank you, Honorable Markey, and then Honorable Mula.
Thank you, Chairperson. I think maybe the problem is we got a blow-by-blow account from the NPA, and the responses wouldn't be from the Hawks wouldn't be as meticulous as that. And I would like to say that if we could get the responses blow by blow from, that would make sense to us. But what I want to say is that we as the Portfolio Committee on Police do oversight over the DPCI. And we are measuring their performance. And if they don't perform, their performance goes according to the cases that they take to court. That is how we measure them. Meaning that if they don't take any cases to court, they are not doing their job. So understanding it in that context, I think I would like to say maybe your measuring instruments are different. NPA's measuring instruments are different from the Hawks. But according to us, as the Portfolio Committee on Police, if they don't take any cases to court, it means they are not doing their job. So it must be understood along those contexts. And I would suggest that you work together even more this time understand, try and synchronize your performance measurements in such a way that it doesn't give us problems. Thank you, Chairperson.
Honorable Mula.
Thank you, Chairperson, and thank you for your briefing. General Matagata, is it true that Mr. Sean Abrams said you didn't raise this issue of delaying? My second question, what measures will you both take in bringing suspects to justice now that they have left the country? My third question, who in the NPA had final authority to make a decision on the matter of issuing the warrants? Thank you, Chairperson.
Thank you, Honorable Mula. Honorable Motapa.
Thank you, coaches. And once more, morning, my colleagues. And thanks for the presentations from both head of National Prosecuting Authority and General Matakata and your teams. Former NPA head, Advocate Bigoli, good morning, and media and all. Chairperson, although as a portfolio committee of Justice and Correctional Services, we're not present when General Matakata raised the issues regarding NPA's hindrance. However, the presentations today to me try to clear whatever may be obtaining, and I'm happy because the two now heads of our very important institutions are more than prepared to continue working together, because without their cooperation as a country we will not be able to fight this scourge of corruption and other very serious crimes. And again, Chairperson, co-chairpersons, I'm very much happy of this multidisciplinary approach in fighting this scourge of crimes. But I'm a bit disturbed, Chairperson, because this issue dates back from last year, around 30 July 2017. In the media, Citizen Sunday Times, it was reported that a task team has been formed regarding the state of capture, and that the NPA had reported to take that report very, very seriously. Now, I thought by then, since then, there were supposed to have been drastic steps which were supposed to have been taken. Now we have, it has been reported that some suspects, I know legally we are not supposed to name some, have left the don't intimidate me, advocate. No, I'm referring to Advocate Mpumlwana. Some suspects might have left the country. Now, my first question, I would like to know: Are you in terms of Friede Farm, correct? Are you not able to implement international instruments which South Africa have ratified to assist in bringing those back to face the might of the law? Another issue, co-chairpersons, is taking much time on only one case. This the last one, the 8th one, Estina, the 8th leg. So other cases, the first up to the 7th leg, what's happening? What's obtaining now? Because I'm afraid. As soon as it appears the DPCI busy with investigations, and I suspect there might be leakage of information. Why all of a sudden, when busy with investigations, the suspects are able to, to evade justice? Your risk management policies of the two institutions, how are they? How safe are they? And then I'm also concerned about those other 1 to 7 legs. What's happening? What's obtaining? Thanks for now, Chair.
Honorable Ramatlakane.
No, thank you, Honorable Chair. Just a few questions from my side as well. I was listening and I advocate you say that you appointed a specialized team to be part of the multidisciplinary investigation. But somewhere in your presentation, you then contradict yourself to an extent that you question the very ability of the investigation, the integrated team that you have deployed. Because nowhere in the presentation is your team able to solve case questions during the investigation if they are integrated. You keep mentioning the advocate governor as the one that is a quality checker. But earlier you did mention that she also formed part of this team, heading actually. But later in your presentation, she also is only a quality controller. That seems to be dragging on questions that are not resolved in the investigation if the integrated approach works. Unless it's just simply integrated by name. It's not sitting together and considering the matters together and be able to say, this is what we must resolve when the docket is submitted, everything is done. So it worries me because this chair, for me, it sounds to me as if it's a sounding board that's standing at a distance, that's not really dirtying their hands in that investigation in an integrated manner. Why will it be that when the docket is submitted in November 2017, your other team then raises the question of the financial analysis when they were part and parcel of this joint investigation team? And why would it be that when there are cases already confirmed by your investigation team, the complex analysis must be the stumbling block to an action? Secondly, you raised the question about, and you keep referring to Advocate Govender, concerns raised about possible flight risk. But nothing is said in terms of that, what has been done to actually mitigate, to deal with that particular question. You say there was some monitoring that was going to be effected. Why isn't it that the very advocate would say, in respect of these, which are the flight risk, this is what we need to do to block it. This is what we need, this is the action that we need, and these are the provision that we can use in the act that governs our function and operation to be able to mitigate that. Or to say, we need to take the passport away, we need to take these things. Those things are all in your purview. They're all in your desk. You can do it. You can apply them. And you're talking about them as back as 2017. And you report that the people left the country during holiday. But why did it seems to me that it looks like people were helped to leave. Was simply helped to this whole thing about backwards and forward and not actioning it, you can raise the concern that I'm concerned about this if the intention is to create a passage. And then on formal record, you have raised it as a concern, and then the passage happened. You covered because you have raised the concern. And I'm not necessarily alleging, but I'm saying you can. So it can be that the whole thing here, and let me take me to the second question, third question, is this selective, how do you deal with this perception of the selective prosecution? That it is there in the media in terms of what, in terms of yourself, 4 months down the line. I think just to go back to the General Matakata's question, is that the docket was submitted. There is no dispute about the docket being submitted in November 2017. The only thing that the NDP suggests is that there was something outstanding in their view. And one of the key was a financial analysis that they wanted it to happen, that they want that to happen. And I don't hear any way to say that was the only leg that on which the case were hinging on. There were other cases that could have been taken. And of course you end all the time, you add on your charges in the process of investigations, or during the investigation if some other cases comes up. Why this is now my towards the end, Chair. I just want, I'm really just worried about this. Or maybe the preservation order on the asset forfeiture, when was that issued? And when was that in fact applied for? Advocate. The SCOPA report, you mentioned the SCOPA briefing. And I assume, Chair, that, or that's my assumption, that as we discuss these matters here, we all are all automatically under oath, or that perhaps it's a different process. But my assumption is that lying to Parliament becomes an offense, without suggesting that anybody is lying, because we can. The SCOPA report worries me. In the SCOPA, when I was reading the SCOPA briefing, it suggested that there were about 100, it's reported to have 100 cases that is prioritized in terms of your report to SCOPA. Now, that, all of which are not part, I don't hear them in a part of the 8 legs that you have spoken about. So perhaps in your, if you go back to SCOPA and refresh your mind in terms of SCOPA, it can also help us to understand that. Thank you, Chair.
Honourable Horn.
Thank you, Chair. First of all, I must add my voice to my colleague sitting to the left in saying that the impression I also formed while listening to the presentation was that the approach here was really very fragmented rather than integrated. And I want to also make the following statement and get some comment from Mr. Abrams, and that also relates to the independence of the NPA in this regard, something you will know we've touched based on many times with him, to say that it would seem to me that from the NPA side, everything only gathered steam in 2018. Before that, I agree with my colleague to the left. It would seem to me that many issues was placed on record formally to come and later say, but we did not, we're not guilty of dereliction of duty. But if we talk about prosecutor-guided investigations, there was no real guidance in terms of saying, look guys, if we need to expedite this, I need this and this and this within the next few weeks, in 2017 at least. There's talk of bail issues being recorded, talk of the DPCI being informed of no prima facie cases against 4 suspects of foreign descent. And then, interestingly enough, there's talk of adequate measures to be being put in place in respect of the flight risk. But that's more or less what is out there, apart from also saying, but yeah, we need the financial investigations. And then, lo and behold, we're informed that everything was put on ice in December. Now, Chair, with the greatest of respect, if the NPA and the DPCI was really serious in tackling this thing of state capture, which has brought South Africa to the precipice, in my respect, there was to be no holiday in December. So I think we need an explanation as to, with time sensitivities around this, and we all know the history of suspects ultimately fleeing the country, why the decision was taken not to proceed in December. Or was it maybe because everybody waited for 20 December around that time to see how the wind will be blowing in 2018? Then, talking about the flight risk, it's interesting that Mr. Abrams says adequate measures was in place. So the question is now, adequate measures to attain what? A defense here, or to prevent suspects from fleeing? Because obviously, quite possibly only the first yardstick could be met in saying to us it was assessed, it was talked about. And then there's talk about monitoring suspects, but yet, on his own version, to my mind, one of the prime suspects fled while arrests at his house was made of other people. So when was the monitoring then stopped? Because obviously by the time the arrests were made, the monitoring was not in place, or obviously were not accurate. Then, Chair, the issue is now, or the case is now postponed till the 17th of August this year. So it's coincidentally more or less a year after the docket was first handed to the NPA to attend to outstanding issues. But I think we must be appraised as to what is this outstanding issues. Will it lead to further arrests? Because the one issue that has not been addressed here, and yesterday we also met with the public protector in this regard, is that the Istina matter and the money laundering and the corruption and the theft of public funds ultimately meant to better the lives of some of the poorest people in the Free State did not happen in a vacuum. It happened as part of the political system, the government system, where politicians is also involved. So we need to be appraised as to what extent has the investigation progressed to look at where the money ultimately went, and to look at how all of this was facilitated and enabled by politicians. Because there's a whole absence at this stage, it would seem, from these two institutions in this regard. And then my last question, Chair, is the Special Director, the way I understand the NPA Act, and specifically Section 24(3), is supposed to act in consultation at all times in performing her duties as the Special Director with the relevant DPP. So I think we need to be appraised as to whether that happened, and if it happened, to what extent, because it would seem that the effectiveness of all of this could also have been hampered by acting in a silo without involving relevant DPPs. Thank you, Chair.
Thank you, Honourable Member. Honourable Breitenbach.
Thank you, Mr. Chair. I align myself, of course, with the questions of both the gentlemen to my left and the very astute points they've made. I would like to, however, ask, in particular, Advocate Governor, about what drove the ideas about arrest warrants and not arresting people. Advocate Govender, in an interview on ENCA, said that arrest warrants are only issued in special cases where suspects were considered a flight risk, not likely to appear before court. Otherwise, and she confirmed that there was no application for arrest warrants made early this year. And she had indicated they decided to summons people to court. Now, I'm somewhat confused. These people are prime suspects. We all know who we're talking about. We're talking about the Guptas, their direct family, Jacob Zuma and his son Duduzane. The Guptas, and at least Duduzane Zuma, are widely known to have assets abroad, considerable assets abroad, homes abroad, access to private aircraft. They travel extensively. They, by their own admission, have more than one passport. If these are not people who are considered special cases and a flight risk, then in my 26 years of prosecuting, I clearly didn't know what was. Because these are the types of people that you would most certainly arrest, that you would most certainly place serious restrictions on. You would oppose bail, and if bail was granted, you would impose serious restrictions on their ability to travel and to move. And bail would be huge amounts of money. None of this was done. It's bizarre. It's completely unheard of. It's impossible that these people could not have been considered flight risks. Yet, nothing was done to prevent them traveling. Nothing was done to limit their ability to leave the country. And go figure, they're all gone. Then, as early as August 2013, the spectre of state capture was in the public domain. The National Treasury and the Public Protector were investigating, and investigative journalists were doing an unbelievably good job of revealing the extent thereof. The police and the NPA both failed to act at all, despite public pressure. There was a forensic analysis available of the Gupta leaks, which became available in the public domain as early as June 2017. There was comprehensive and unbelievably good forensic analysis available. And the only thing that remained for the police and the NPA to do was to verify that information. The information was there. It was all there. All they had to do was verify. That's not a hard job. Mr. Abrams has made a long song and dance this morning of telling us what a hard job it is. It's not. Been there, done that, got the T-shirt, it can be done. But surprisingly, for as long as Jacob Zuma remained president of this country and in control of the system of patronage, no action was taken against any one of those people. And it was obviously politically manipulated, that even they could see it. However, astonishingly, as soon as Zuma lost his grip on power, as soon as he was obviously no longer the flavour of the month, the police flew into action, and the NPA flew into action. And even then, no one of significance has been arrested. The main perpetrators have all been allowed to leave the country because they were not regarded as flight risks. Really. It's painfully obvious that this entire process has been politically driven. Both the police and the NPA are required by law to act independently. They haven't done that. I would like an explanation. I must also add General Matakata specifically. I was a prosecutor for 26 years, ma'am. I have never witnessed a prosecutor throwing anyone under the bus like you were thrown under the bus today. It's a disgrace. Prosecutors and police are supposed to work together. They're supposed to protect each other. They're supposed to help each other. You clearly had none of that. It's a great, great pity because it's obvious that you're trying to do a damn good job. Then I have a question for Mr. Abrams. Is it correct, Mr. Abrams, and I have this on very reliable information, that you deliberately blocked any asset forfeiture action on Trillian. You allowed them grudgingly to proceed on McKinsey, and you made it very clear that no action will be taken on Trillian until after the ANC elective conference. Is that true? And if it is, I'd like an explanation. Everett Adams comes here today and tells us about all the work they did, and he listed it very efficiently and effectively. Talks about 373 Section 205 subpoenas. Now that sounds impressive. It sounds like a lot of work. I want to tell you it isn't. A Section 205 subpoena is a pro forma document that gets done almost every single day, and most of the work's done by the police. Prosecutor signs it, and that's it. It's not impressive. It's not a lot of work. And that goes for a lot of the documents he suggested. Mutual legal assistance, 8 countries, 7 countries engaged. Once you've done the one application, they're pretty much all the same. You just change the name of the country. It's not that hard. There was a lot of talk about bail information.
Just coming out there of that parliamentary committee that is taking place, where the National Prosecuting Authority and Hawks are briefing a joint committee of the Police and Justice on the progress. Of course, we've heard Sean Abrams bring forward his briefing, and now he is being questioned by other members. We'll now move over to the Supreme Court of Appeal in Bloemfontein. We do know that a hearing of the matter involving 2 high NPA ranking officials is also going to be taking place. Before we do that, however, let's have a look at some other news stories making headlines at the half hour. South African actress Nomzamo Mbasa has challenged Africa's private sector to pull together resources and help alleviate suffering refugee camps in Kenya. Officials are hoping that today's presidential election in Sierra Leone will be peaceful. More than a dozen candidates are vying for votes. The British-based Syrian Observatory for Human Rights says 80 people were killed and more than 300 wounded by airstrikes in Syria. Indeed, one of our top stories this morning, the Supreme Court of Appeal in Bloemfontein is hearing the matter involving the future of 2 high-ranking NPA officials. Senior NPA executives say that the High Court in Pretoria misdirected itself when it ordered the pair to be struck off the roll. It includes the Deputy National Director of Public Prosecutions, Advocate Nomgcobo Jiba, as well as Specialized Commercial Crimes Unit Head Lawrence Mrebi. Let's cross live.
It's in that context that the Breitenbach Memorandum is discussed. And this court rejects that argument that the internal remedies should have been exhausted before coming to court, because the court said no. Ms. Jiba received this memorandum in April 2012. She did nothing about it. So what purpose or what point will it serve if Full must now go back and exhaust the internal remedies under Section 22(1)(c) as an interested party, for example, when she has already been placed in possession of this memorandum? It's only in that context that if I can just find the judgment in this court at page 282, volume 2. Under the subheading exhaustion of internal remedy at paragraphs 36. The NDPP's final argument as to why review proceedings were not competent was that Full had failed to exhaust an internal remedy available to it. And then at paragraph 37, In this case, we know that Advocate Breitenbach made a request early on to the NDPP, which was supported by a 200-page memorandum, in fact it was a 20-odd-page memorandum, that the latter should intervene in Mkhwebi's decision to withdraw the fraud and corruption charges. In addition, the dispute had been ongoing for many months before it eventually came to court, and during that period it was widely covered by the media. But despite this wide publicity, the high-profile nature of the case and the public outcry that followed, the NDPP never availed itself of the opportunity to intervene. Against this background, Full could hardly be blamed for regarding an approach to the NDP as meaningless and illusory as a matter of some urgency. And that's all that this court had to say about the Breitenbach memorandum. The decision or the failure to take a decision in terms of Section 22(1)(c, that decision was not before the court and was not taken on review. We deal with the Breitenbach memorandum at page 30 of our heads at the bottom. There's a subheading, Findings in relation to the Breitenbach memorandum. And at paragraph 48 on page 31, we say that the Court Quo made several findings in relation to the Breitenbach memorandum, upon which basis it concluded that the first appellant had deliberately intended to mislead Murphy J. in the Mluli matter. First, the Court Quo found that the first appellant had acted deliberately and with intention to mislead Murphy J. in not disclosing the Breitenbach memorandum. Having regard to the following considerations, we submit that the Court Quo clearly erred in reaching this conclusion. First, the Breitenbach memorandum would never have been part of a Rule 53 record, as the Mluli matter did not concern a review of a decision by the first appellant for the reasons we discuss in our heads. Secondly, it was in any event produced some 5 months after the impugned decision of Mkhwebi was taken, and therefore could not have formed part of a record of decision. Third, we say the Breitenbach memorandum was not relevant to an issue in dispute in the Mluli matter, in that first, the first appellant's decision not to act under Section 22(2)(c) of the NPA Act was not on review. Secondly, the existence of the Breitenbach memorandum and the first appellant's knowledge of it was raised by both Murphy J. and Brandt J.A. in the context of an argument that the review application brought by Full was premature, as internal remedies had not been exhausted. In essence, both Murphy J. and Brandt J.A. held that as the first appellant was aware of the Breitenbach memorandum and had nevertheless not reviewed the decision of the second appellant, Full could not be blamed for regarding an approach to the first appellant as meaningless. Then third, and this is most important, as appears from the decision of Murphy J., the Breitenbach memorandum was in any event placed before the court by Full. Murphy J., however, made no remark at all as to the alleged non-disclosure of the memorandum. And then we add that there's nothing in the Halgrein memorandum, nor in the Matau memorandum, which Matau prepared after the Murphy J. judgment was handed down, advises that the Breitenbach memorandum should have been disclosed by the first appellant. As regards the record, I've already made the point that Jiba's involvement in all three matters, Boyson, spy tapes and Ludley, was through a team of officials of the NPA acting through the Legal Affairs Division, who in turn instructed the State Attorney and Senior Counsel to represent the NPA. At no time did she conduct the litigation in these matters, either personally or as counsel. The court, however, was not willing to accept this explanation, finding that Ms. Jiba was relentless in opposing the review application brought by Full and did everything in her power to protect Mdluli. To quote Lagodi J, she was steadfast to do everything in her power to ensure that the charges against Mdluli were permanently withdrawn. And as a result, the court held that this demonstrated mala fides and an ulterior motive. Now, the answer to this is simply that there's absolutely no evidence whatsoever that links Ms. Jiba to Mdluli. Absolutely no evidence. The decision in relation to Mdluli were taken by Mkhwebi and Chauki. The first decision to withdraw charges against him was before she even took up the position as acting National Director of Public Prosecutions. The second one, when she had barely been in that office for 2 months. The court quo, Mr. Justice Lagodi, also seems to somehow link Ms. Jiba to a letter that Mdluli wrote to the President in November 2011, before she took office. There's this letter that Mdluli wrote to the President and say, well, if these charges are going to be withdrawn, then I'm going to help you win the election in 2012, which was, I think in both courts said that's apparently a reference to the ANC National Conference, which took place in 2012. And somehow, Mr. Justice Lagodi links all of this together in a manner which is not supported by the evidence. There's nothing on the facts to suggest that Ms. Jiba even knew Mdluli. Some kind of a conspiracy theory. And this with respect, because if one looks at Lagodi J's judgment, he even says in terms that Ms. Jiba should have taken into account the character and personality of Mdluli. Now, again, this is not supported by the facts. She didn't take those decisions to withdraw charges against him. And certainly it would be a novel basis on which to decide whether or not to prosecute a suspect on the basis of that person's personality. Surely you look at the information, the prima facie evidence that's there, and you make a decision whether there are reasonable prospects of a conviction.
I think the whole case, is about whether or not she made a decision, to discontinue the charges. It's what happened thereafter. What happened after the decision by both directors to discontinue the trials, her conduct. That is what I think the GCB is about, her conduct in dealing with what transpired thereafter.
But it's an inference that is drawn by Mr. Justice Lagodi that has absolutely no basis.
Yes, I hear you on that aspect.
We submit that the court had placed an undue weight on the quote-unquote kind of personality that Mluli appears to be, and found that, and in so doing found that Ms. Jiba had brought the NPA and the legal profession into disrepute by failing to prosecute Mluli, who had inappropriately suggested that he was capable of assisting former President Zuma in the event that charges were dropped. And by implication, as I submitted, that this was a reason for Jiba's conduct. There's no evidence whatsoever that Ms. Jiba would gain any personal or professional benefit from withdrawing charges or being party to withdrawing charges against Mluli, or that her conduct was motivated by some desire to protect him. In fact, the GCB itself, in their founding affidavit, had not drawn any causal link between Mluli's letter to former President Zuma on 3 November 2011 and the withdrawal of charges. But Lahore J does so. We submit that this...
We'll link out of this. Of course, Nomgcobo Jiba as well as Lawrence Mrebi are appealing court decisions to strike them off the role of advocates in their inquiry in Bloemfontein in the Supreme Court this morning. We'll now also be crossing over to another parliamentary inquiry. Former ESCOM board chairperson Ben Gubane is giving evidence in the parliamentary inquiry into ESCOM this morning. Let's cross live.
Minister's attention. 2.5.6, as at 9 February 2016, however, a formal response to the letter addressed to the minister has still not been received, and at that time, there was no formal contract of employment with Mr. Molefe. 2.5.7, on 9 February 2016, the People and Governance Committee met to deliberate on the conclusion of a contract of employment with Mr. Molefe, including the issue relating to his pension benefits. In order to better understand the distinction between appointing Mr. Molefe on a fixed term as opposed to a permanent contract basis and the options available to the board for addressing Mr. Molefe's concerns, Mr. Minar guided the board. As already mentioned, Mr. Minar explained to the board that due to Mr. Molefe's short-term contracts with numerous public entities in which he served at executive level, he was deprived of the opportunity to grow a pension fund in a single fund. 2.5.8, it was then resolved at the meeting of 9 February 2016 that 7.5.1, the current ESCOM Pension Provident Fund ruled that employees may proceed on retirement from the age of 50 with 10 years service remains applicable. 7.5.2, in cases where an executive director appointed on a fixed-term contract decides to take an early retirement, and there is a shortfall regarding the ESCOM Pension and Provident Fund 10 years service rule, ESCOM shall 1, bridge the gap to make up for the 10 years, 2, waive the penalties applicable to early retirement, and 3, refund the ESCOM Pension and Provident Fund actual costs for additional service added, plus penalties applicable to early retirement. 7.5.3, a proposal in respect of the Chief Financial Officer was to be considered and submitted to the committee in due course. A copy of this resolution is attached and marked BN 13. 5.5.9, it was the intention of the People and Governance Committee that the arrangement had to be structured in such a way that the benefit would only accrue to Mr. Mlife upon completion of his 5-year term, and that Mr. Mlife would not be able to participate in any other government pension fund after qualifying as per the resolution. Such intention was communicated to the Minister on 25 November 2017. 2.5.10, on 7 March 2016, Mr. Mlife signed a second contract of employment for a fixed term of 5 years with effect from 1st October 2015 and terminating on 30 September 2020. On 19 April 2016, the board approved the resolution of the People and Governance Committee meeting of 9 February 2016. 2.5.11, on 6 September 2016, it was decided to increase the long-term incentive award for Mr. Mlife to 2 times the annual pensionable earnings on the basis that the amount was relatively low based on the benchmark against similar long-term incentive awards to the chief executives at this level. 2.5.12, on 24 October 2016, the People and Governance Committee approved the additional award in the form of an increase to Mr. Mlife's long-term incentive to 2 times the annual pensionable earnings. 2.6, the eventual payment of pension benefits to Mr. Brian Molife. 2.61, on 11 November 2016, Mr. Mlife formally submitted his request for an early retirement in terms of the ESCOM Pension and Provident Fund rules, read together with the resolution of 9 February 2016. In the same letter, he also indicated that his last day of service would be on 31st December 2016. A copy of the said letter is attached, marked BN14. 2.6.2, on 15 November 2016, the ESCOM Pension and Provident Fund provided an early retirement calculation for Mr. Mlife based on the exit date of 31 December 2016. The total cost to ESCOM for early retirement would be an amount of 25 million. Hang on, there's something wrong here. 25,802,004.19. I think I'm reading it right. 2.6.3. On 21 November 2016, Molife's retirement was discussed at a special People and Governance Committee meeting. During the meeting, the terms of the letter requesting early retirement were supported. 2.6.4, on 24 November 2016, the response was provided to Mr. Mlife, in which I approved his request for early retirement in terms of Rule 28 and Rule 24.1 of the ESCOM Pension and Provident Fund rules. I also confirmed that all penalties would be waived and further early retirement be on the basis that Molife be deemed to have achieved the age of 63. A copy of my approval letter is attached here to, marked BN15. 2.6.5, on 23rd March 2017, the amounts paid to Mr. Mlife in respect of his salary up to December 2016 were 575,679.91 cents. Leave due to him in an amount of 226,278.84 cents, and a short-term bonus to the end of December 2016 in the amount of 2,110,185 rand. The total amount paid to Mr. Mlife was the sum of 2,912,143.75 cents. 2.6.6. On 19 April 2017, the Minister called a meeting to discuss Mr. Mlife's pension payout. It became evident at this meeting that my letter to the Minister dated 25 November 2015 was not accepted by the Minister. The Minister stated in no uncertain terms that funds in the amount of 30,103,915.62 cents paid to the ESCOM Pension and Provident Fund in respect of Mr. Molife's early retirement would not be permissible and should be repaid. 2.67, following the meeting with the Minister, Ms. Klein and Ms. Daniels had a meeting later on that evening with Mr. Mlife, where it became apparent that he was already paid out 30% of the pension benefit in January 2017, and was also receiving monthly pension payments of 100,000 rand since then. 2.6.8, according to Mr. Mlife, he only received 7,700,000 from the Eskom Pension and Provident Fund on being admitted to the Eskom Pension and Provident Fund, and of this sum, 4,300,000 had been transferred from the Transnet Pension Fund to the Eskom Pension and Provident Fund. The employment, 2.7, the employment of Mr. Singh as Financial Director at Eskom. 2.7.1, on 1st August 2015, Mr. Singh assumed the role of CFO at Eskom on secondment from Transnet, where he had held the position of CFO from about July 2012, having acted as the CFO since about 2005. 2.7.2, on 28 September 2015, the Minister announced that Cabinet approved the appointment of Mr. Singh as the CFO at Eskom in conjunction with Mr. Molefe's appointment as Group Chief Executive and my appointment as Chairman. 2.7.3, on 2nd October 2015, when the Minister approved the appointment of Mr. Mlife as Group Chief Executive and addressed a letter to me in this effect, a copy of Mr. Singh's appointment letter was also enclosed therein. The letter confirmed Mr. Singh's appointment as CFO from 1st October 2015. However, there was no indication of the duration of his appointment. Please also see paragraph 2.4.11. 2.8, Eskom's response to the Public Protector's report on the state of capture, dated 14 October 2016. 2.8.1, the responses to issues that were raised by the Public Protector during her investigation were prepared by and submitted to the Public Protector by the Company Secretary and Head of Legal Services, Ms. Daniels. 2.8.2, the board did not respond to the Public Protector's report, but we had a draft on this, which I hope has been circulated, of our response. When the report was published and made available to the board sought and obtained legal advice and guidance from senior counsel on what its rights and obligations were. In particular, the board sought guidance as to whether or not it could take the report on review on the basis that the Public Protector had not given the board and or any of the individual directors specifically mentioned in the report an opportunity to respond to the issues raised therein in relation to them. 2.8.3, Senior Counsel's opinion was that the Public Protector's report did not contain any findings, but instead it contained what he referred to as being observations. On that basis, he opined the report could not be taken on review. 2.8.4, in amplification of his views, Senior Counsel pointed out that the primary remedial measure employed by the Public Protector's report was that a judicial commission of inquiry had to be established, and that this remedy fits logically and appropriately with an investigation that was not as detailed as it might otherwise have been. 2.8.5, in other words, as Counsel concluded, the impact of the report was to record a number of potential violations of law based on the information that was made available to the Public Protector, and the call for a commission of inquiry to be appointed to make the final findings on these allegations of unlawful conduct. 2.8.6, the board accepted Senior Counsel's advice. Hence, no further action was taken in relation to the Public Protector's report. I think this is the end of the issues that we agreed I should address.
Just deal with the 2.9, Doc. Yes.
All right. 2.9, the purchase of Optimum Coal Holdings by Tegeta from Glencoe. This is not an issue that I was engaged in, but I collected as much information as I could, and that's what I'm presenting. 2.9.1, pre-purchase of coal from Optimum. 2.9.11, on 8 December 2015, a round-robin resolution was submitted to the board by management. The submission was titled Pre-Purchase of Coal from Optimum Coal Mine. That part of it I was involved in. 2.9.1, the motivation for the round-robin dealt with the security of coal supply to the Hendrina Power Station in light of the fact that Optimum Coal Mine was placed under business rescue. 2.9.13, as part of motivating for this transaction, Mr. Machela Koko indicated that given the serious risk of security of supply to Hendrina Power Station, Komati Power Station, and Anod Power Station, all of which are of key national interest, he considered it appropriate to bring this to the attention of the Director General in the Department of Mineral Resources. Mr. Koko then requested intervention by the Department of Mineral Resources to obtain a resolution of the problem of coal supply. 2.9.1.4, the Director General of the Department of Mineral Resources responded in a letter indicating that they would engage with the parties and take certain steps to assist in considering the significant risk to the country. 2.9.1.5, the department requested that ESCOM play an active role in supporting the rescuing of the mine and return for securing the honoring of the current contract up to 2018, to consider making a prepayment for up to 1 year coal supply. This was to ensure that supply was guaranteed and averting any national crisis. 2.9.16, it was indicated that with the funding of the pre-purchase of coal, ESCOM was going to achieve a value benefit of 238.9 million rand. The motivation by management further indicated that the proceeds of the 1.86 billion prepayment of coal were to be used by Optimum Coal Mine to extinguish existing liabilities to ensure that the business continues as a going concern. It further stated that the shutdown of Optimum Coal Mine could potentially result in thousands of job losses. 2.9.17, pursuant to the above-mentioned motivation / recommendation, the pre-purchase of coal was then approved by the board by a round-robin resolution on 9 December 2015, after the Investment and Finance Committee of the board had made the recommendation formally. 2.9.18, based on all the submissions made by management, the board believed that this payment was for the pre-purchase of coal from Optimum Coal Mine. The board only learned from the press in July 2017 that management had, in fact, converted what was meant to be a prepayment for coal into a guarantee. 2.9.1.9, on the 10th of October 2017, Ms. Caroline Henry, who was the Senior General Manager for the Treasury Department in ESCOM, decided that instead of laying out the 1.6 billion rand in cash, she would prepare a note and rather request that a guarantee in favor of Tegeta be issued through ABSA. 2.9.1.10, according to Mr. Singh, ESCOM's former CFO, quote, the issuance of this guarantee was brought to the attention of various Treasury officials via emails, who all thus had knowledge that the guarantee was issued. This is over and above Ms. Caroline Henry's, the head of Eskom's Treasury. By and large, this was the Treasury Exco. This evidences the fact that the issuing of the guarantee was not concealed or kept from the sight of the responsible officials in any way, end quotes. 2.9.2, purchase of Optimum Coal Holdings, Pty Limited, OCH, by Tegeta from Glencoe. 2.9.2.1, in December 2015, the sale and purchase agreements for the sale of shares and claims, SPA, was signed. Tegeta purchased all the shares in the issued share capital of Optimum Coal Mine and purchased claims against Optimum Coal Mine from Optimum Coal Holdings for an amount of 2,100 million. 2.9.22, the suspensive conditions of the SPA were inter alia that 2.9.2.21, Eskom must consent to the sale and purchase of shares by Tegeta. 2.9.222, release of the guarantee provided by Optimum Coal Holdings to Eskom. 2.9.223, Tegeta to issue a guarantee to Eskom in respect of the obligations in the coal supply agreement. And 2.9.224, cession and assignment of rights in the coal supply agreement to Tegeta. 2.9.3, to my knowledge, Eskom was not involved in the purchase of Optimum Coal Holdings by Tegeta, which was a commercial transaction between two private companies, nor the negotiations of the terms of the SPA. The role which was played by Eskom was to secure its interest in the coal supply by Optimum Coal Mine, pre-purchase of coal from Optimum Coal Mine by Eskom. And to that extent, the conditions precedent mentioned above were inserted to protect Eskom's interest. 2.9.4, my understanding is that Eskom's involvement in the sale and purchase of shares and claims by Tegeta from the business rescue practitioner of Optimum Coal Mine was limited to the approval of the cession and assignment of coal supply agreement from Optimum Coal Holdings to Tegeta. And this was confirmed by the public protector in page 251 of her report. 2.9.5, my understanding is further that on 8 April 2016, Tegeta made an offer to supply additional coal for the Anot power station from Optimum Coal Mine over a period of 5 months. This offer was made subject to a prepayment to be made by Eskom for the supply of such coal. 2.9.6, the board was advised that the purpose of prepayment was to secure coal for Eskom, more particularly of the high quality that was required by Anot power station, and further to ensure Tegeta's ability to meet the production requirements for both Hendrina and Anot power stations in the short term. 2.9.7, in line with the above, on 11 April 2016, Eskom management approached the board tender committee to consider on an urgent basis the purchase of coal from Tegeta to supply Anot power station for 5 months. The benefits for extending these short-term contracts were presented to the board tender committee as including the following. 2.9.7.1, the fact that the coal was being mined and could be delivered without delay. 2.9.7.2, to alleviate the coal shortfall at Anot power station due to the closure of Anot colliery. 2.9.7.3, to alleviate the shortfall of coal requirements at Kriel power station due to the underperformance of Kriel power station underground mine. 2.9.74, by procuring this coal for Anot and Kriel power stations, it would assist towards building stock days. 2.9.8, the above mentioned requested approval by management was made in terms of Eskom's supply chain procedure which provides inter alia that whilst Eskom does not encourage the provision of advance payments, an advance payment may be acceptable strategy for Eskom in certain circumstances. For example, 2.9.8.1, in cases where the supplier will have to make a big capital outlay before starting with the contract, and 2.9.8.2, it will only be issued on condition that the relevant contractual provisions relating to advance payments also need to be included in the contract. 2.9.9, the Board Tender Committee approved prepayment to Tegeta in the requested sum of 659,558,079 rand 38 cents. This was inclusive of VAT. The approval was made subject to the following conditions. 2.9.9.1, Eskom had negotiated a 3.5 discount with Tegeta. 2.9.92, Tegeta had obtained adequate and appropriate security for the transaction to safeguard Eskom's interests. And 2.9.93, Eskom management had provided a rationale for the commercial value that the transaction would have for Eskom. 2.9.10, my understanding is that in the Eskom environment, prepayment of this nature is not necessarily unique and has been done in the past. It forms part of the procurement mandate approved by the Board Tender Committee in 2008. It is used in large projects, coal mining contracts, and emergency supply contracts. 2.9.11, in this regard, it is also noteworthy that in her report, the Public Protector stated, quote, after evaluating the responses received from Eskom, it is clear that they do have the requisite policies in place which provide for a prepayment of coal to be made. This is in line with various agreements put in place by Eskom after the energy crisis in 2008, close quotes. 2.9.12, however, the Public Protector also made the comment, quote, that Eskom had previously done extensive due diligence on the Optimum coal mine, which formed part of the cooperation agreement. They were aware of the exact production outputs for coal and the price of coal being supplied by Optimum coal mine. At that time of concluding the contract with Tegeta for the supply of coal to Arnold Power Station, Eskom was fully aware that the sale of all shares in Optimum Coal Holdings to Tegeta had not gone through. It appears to not make commercial sense for Eskom to contract with Tegeta for a higher price of coal, knowing exactly where the coal was being received from, close quotes. To that end, I point out that a preliminary legal opinion obtained by Eskom on this transaction indicated that Eskom was not in contravention of the PFMA in executing this transaction, as it related the provision related to irregular and fruitless and wasteful expenditure. Financial sustainability is the overarching objective of the Eskom coal strategy, namely optimize value from the existing cost-plus mines, para 8.2 to 8.4. Conclusion. I trust that this submission will assist the committee in the finalization of its inquiry. Signed by me on the 5th of March, 2018.
Thank you, Dr. Ngubane, for the presentation. I will now give over to the advocate to lead us in questioning.
Doc, can you just switch off the mic, please? I'm not going to cover a number of issues with you, Doc. I'm going to pursue three. Firstly, I would like to confirm that your statement forms part of the record of proceedings in its entirety, together with annexes. Secondly, I just want to go back to a meeting that took place last year, the 2nd of March, 2017, wherein the board, it was a special board meeting, you were chairing.
I think it was a PNG meeting on the 2nd of March.
Okay. What were the issues that you discussed at that meeting?
I think there were a couple of issues touching upon the recruitment process and other PNG issues. However, I brought to that meeting a document that I found on my desk, which was not dated, not signed, putting certain allegations about Mr. Machela Koko. I gave this to the board members, and we came to the conclusion that we had to give this document to Mr. Koko and ask him to respond by end of the working day to what was raised. The statement was duly given to Mr. Koko. Somewhere in the afternoon, before the scheduled meeting, he came to me and said, well, of course, this timing was not sufficient. But he also told me that he was facing a lot of difficulty as acting group chief executive because he was moving people around at Medupi and Kusile because of certain serious issues. He didn't go much into the issues, but he mentioned things like fictitious companies were being created and funded. But he was handling this as a group chief executive together with ESCOM Security. And then I went back to my colleagues. When we came to the meeting at about 6, I think, the intention was to suspend Mr. Koko and institute an inquiry. But in our discussions, it emerged that actually we needed to give him 48 hours for a response before you can suspend a person. And of course, the issue that there was no name to the document raised the issue of this being not a grievance letter, but a whistleblower document. Now I was reminded that ESCOM policy requires whistleblowers to be dealt with through the Audit and Risk Committee and through the Assurance and Forensic Division of Internal Audit. We then took a decision to submit this document to the Audit and Risk Committee, who subsequently dealt with it through Assurance and Forensic, and this led to the inquiry that eventually took place.
The subsequent chair or acting chair of the board testified here around this particular issue that it was your unilateral decision not to suspend Mr. Koko. That is Mr. Zatemba Koza. What is your response to that?
Well, I don't know where he takes this from, because we had a meeting and we discussed this matter quite extensively. And then I said, ultimately I said, well, let's refer this thing to audit and risk and let it be handled as a whistleblower document. So there was no time when I took a decision alone. We're all at a meeting. So.
We do have on record the meeting in question. And if you want, we could play the meeting. It was very clear that meeting that it was not only the complaint that you had received, but rather most members of the board had received various complaints in respect of the same individual. But what that meeting was clear on was that there will be a meeting at 6 o'clock, and Mr. Koko would be called in at 6 o'clock to give reasons as to why he would not be suspended. Is that your recollection of the resolution of that earlier meeting?
That is correct.
Now, your testimony is that out of the meeting, you went to meet Mr. Koko.
After I received the document to which he had to respond, he then asked to see me.
I guess you didn't know what he wanted to see you in connection with.
I assumed that it was because of the document that he had received and had to respond to. So I granted him the meeting.
Sorry, you've lost me a bit. You assumed it was in connection with a document he would have received.
No, he got a document to which he had to respond, or else face suspension.
How did he get the document?
It wasn't me who delivered, if I remember well, personally. But you know, there are people at ESCOM who do those issues like sending messages and so on. I'm not sure of the precise mechanism.
I guess the question is, on whose instruction was that document sent to Mr. Koko?
It was a decision of the meeting that we had earlier, where we decided that he must respond or face suspension.
I recapped the decision of that meeting to which you agreed. He was to be called at 6 o'clock to provide reasons as to why he should not be suspended. So in other words, at 6 o'clock, he comes to a meeting, he's given reasons or allegations against him, and is told to respond to those allegations.
Well, probably your tape puts it differently. The earlier meeting took the decision that we must get a response from him in terms of the allegations. And the decision then was that he will be suspended if those reasons or responses are not to the satisfaction of us as PNG and the board.
That record will show that you people had already taken a decision to suspend him until you were persuaded by Mr. Zatemba Khoza to call that meeting at 6 o'clock, wherein he will be given an opportunity to respond in the same manner when you called the meeting on the 11th of March to suspend Messaris Machela Koko, Mr. Sidiso Matona, Ms. Sulufelo Molife. That's the process that you followed, isn't it?
I mean, that was a totally different process, which was brought upon us. This one was by us to say, here is a document with serious allegations. He must give a response to us. And the document was sent to him so that he can give a response. And then if we are not satisfied, we will suspend him.
That record is very clear. It's not been disputed by any of the other board members that attended the meeting. You had made up your mind, having been persuaded by other board members, yourself included. You wanted him gone, as in yesterday, until you were persuaded by Mr. Koza at 2 o'clock. What is it that persuaded you personally from what Mr. Koko told, resulting in you not suspending him?
Well, the issue of time was raised for the first time, that actually to suspend, we need to give a person 48 hours to respond why the person should not be suspended. That arose for the first time in my meeting with him.
What is the other reason, besides the 48-hour notice, that stopped you from suspending him, if any?
Well, this was a dynamic process. You know, you may have in your minutes formal discussions, but I mean, we're all at Megawatt Park, we're all talking about this, and it was clear that we had also omitted the policy requirement that this thing must go to audit and risk, who must deal with it through forensic assurance and forensic. It's a policy at ESCOM. So to suspend him directly on a whistleblower note without going through this process would have been illegal.
So this was the whistleblower, you took that into consideration. What other factors you took into account to arrive at that decision? If any, of course.
This was part of the discussions that we were having. And so, I mean, obviously it would have taken us to court, to the CCMA and Labour Court, and won if we took steps that were not in law or in policy.
So to add to the reasons, it was a threat of litigation. Okay. Now let's look at these 3 reasons that you've advanced to entertain how rational your decision was. 1.
Advocate, it wasn't just my decision. We were there as members of the board who are also members of PNG. I did not just say no suspension anymore. You know, it was a product of our consultation.
Now I take your evidence to the extent that you're making that, you're testifying on that, but I need to take into account what other board members have said as well. But on your version that it was a collective decision, it is now before, let me rather put it this way, 48 hours had elapsed and you had not suspended him. So we can tick that off. as not the reason why he was not eventually suspended. Because the 48 hours did come, it went, and he was not suspended. So we can tick that off.
No, 48 hours. By that time, we'd referred the matter to the Audit and Risk Committee, who then took it further and eventually led to dealing with the issue.
But after 48 hours, he had not been suspended.
That's correct.
Who was the chairperson of Audit and Risk? Was it not Ms. Mabunda?
That's correct.
She was at the meeting, the earlier meeting of the People and Governance meeting.
That's correct.
She was also vocal that Mr. Koko had to go.
Correct.
Over and above the whistleblower report, there were other issues that you had raised, including yourself. You had a note from a meeting between yourself and the minister, where the minister had raised serious concerns about the same individual. Is that not correct?
That's correct.
Why were those factors not considered, which you considered at the meeting as part of reasons to suspend him? Is that not correct?
Absolutely.
So why did that package of other issues, except the whistleblowing, which formed part of your decision to suspend him, not stand at the 6 o'clock meeting to suspend him, barring the whistleblower?
Well, I don't have the copy of the whistleblower document before me, but there were many issues raised in that document. You know, and it was the collectiveness of those issues that made us decide to suspend him.
Let's for once.
And also, let me just add, I'd shared the note from the minister with these same board members. We had shared that information, and we knew that it was something that has got to be dealt with.
The point I'm making, Doc, you had received this whistleblower note, which you had shared with that meeting of the People and Governance earlier in the day. Correct?
That's correct.
Over and above that document, you contributed other reasons why he should go. You've just admitted to that.
That's correct.
Ms. Mabunda contributed additional reasons why the man had to be suspended.
That's correct.
Ms. Klein, who said you people must stop pussyfooting around this man, advanced reasons as to why he had to go. Correct?
That's correct.
Now, in your meeting with Mr. Koko, and one of the reasons you did not suspend was because of the report, the whistleblower report. Now I'm saying, I understand that, put it aside. Why, when you at that meeting, based on the contributions of yourself, Ms. Klein, Ms. Mabunda, and others at the meeting, which made you to come to the conclusion that he must go, why did you not, on the basis of those, at that meeting, suspend him?
But I've said, Advocate, that the issues contained in this document encompassed a lot of other matters. However, even if it was on a single issue that had been seen on its own separately, you still have to follow procedure in suspending a person. But here was a document which contained a whole lot of allegations that we're looking at, and then deciding that this thing has got to follow the route of the whistleblower. We did not pick out individual items that we had heard from or discussed before. We were looking at that document which contained these allegations.
The ESCOM inquiry, of course, Ben Ngobane responding, saying that ESCOM's board never necessarily responded to the public protector's recommendations. We now cross to another briefing taking place in Parliament this morning. The National Prosecuting Authority and Hawks are briefing a joint committee of the Police and Justice on progress and challenges regarding the prosecution of state capture. Let's cross live.
Have had other people or suspects having fled the country. What measures in terms of monitoring them as being flight risks? And I think in that response that we'll give, in the report that we'll give, I will state also clearly what transpired in terms of the indication that some of the suspects are flight risk and how soon should we proceed with these matters. But what I would like to point out, in the absence of any warrant of arrest that was there, it was not going to be possible to flag, if I may put it like that, people who were not yet at that time wanted or were perceived. But in terms of monitoring, it might be monitoring if the people are around the country as yet or not. There's an indication that some of the people or suspects left in August already, 2017. So it was 2 people that had been out of the country by that time. It's not as if it was the entire, or it was not as if it was the probably most of those who are from foreign countries. But what I would want to point out is that in us monitoring those that would have been arrested, we couldn't flag them with any other department before people were given any warrants of arrest for them, because otherwise we would be probably breaking the law. I would hand over.
Thank you. Thank you, General Matakata, chairpersons, members of the committee. Let me firstly start off by dispelling the misperception that has been created in respect to the briefing that I made. I certainly had no intention or for perception to be created that I've thrown the proverbial throwing of General Matakata under the bus. That certainly was not the intention at all. It was merely a report that I had been given about the historical facts as to the engagement between the 2 parties, and I wanted to give a rendition of that. So if that perception was created, we have a very great working relationship, and I want to apologize if that was the perception that was created. It certainly was not the intention, because I truly value the relationship that we have. Notwithstanding, let me continue and address the issues that have in fact been raised by members of the committee. The President promised in his State of the Nation address that he's going to deal aggressively with corruption, and the question is, should any delays in this regard be seen as sabotage? I think with regards to the work of the NPA, we of course play a critical role, roles in the ACTT, and during our strategic planning session in November last year, we resolved to, of course, adopt a more aggressive stance in our approach to fighting corruption, maladministration, together with our stakeholders. Now, some of the powers that the National Director does have relates to the appointment of investigating directorates. So, as a leadership of the institution, we interrogated this issue, and of course we then left it to the DPPs and the special directors to identify cases within their areas of jurisdiction where investigating directorates can be appointed in respect of those specific matters. So a few submissions have been made to me where I have signed off on investigating directorates for the Special Director and the DPP to take the lead in that regard. Of course, we will work closely with the DPCI and other stakeholders on these issues. Of course, there's different scenarios. The NPA Act makes provision for the President to appoint an investigating directorate. We did not adopt that approach, during last year or this year. Section 72 of the Prevention of Organized Crime Act and Section 22 and 23, or 23 and 24, 22 and 23 of PECA, our domestic corruption legislation, makes provision for the National Director to appoint investigating directorates. Similarly, as I alluded to earlier on in my presentation, the head of the Hawks has the power to request the National Director to appoint investigating directorates in respect of matters that are meritorious or of such a grave nature for that approach to be adopted. And I think the time has come for that approach to be adopted. It's something that we will also discuss further, specifically with regard to ACTT related matters. So to answer the question, could delays be seen to be sabotage? I can assure you from the NPA side and the working relationships that we've had with the Hawks to date, I cannot say that a delay in matters is a direct result or akin to sabotage. I wouldn't say that at all. There are various reasons why matters are delayed, and I think to ask a question and say, is there deliberate sabotage? I don't know of any matter where there has been deliberate sabotage in respect of an investigation. On the question, what do we intend doing in respect of, the foreign nationals that are linked, and in respect of whom warrants of arrest have been authorized or linked to any of the state of capture investigation legs. Of course, the intention is to apply for the extradition of the individuals concerned. The challenge that you have when you apply for an extradition, if, for example, we apply for the extradition of suspects in the Estina matter, then we are only bound to try them in respect of the Estina matter, and we can't charge them in respect of the other matters in which they are potentially linked to. So it creates a bit of a difficulty in respect of the entire investigation and the strategy in which the prosecuting team intends adopting or has adopted in respect of the accused. And one really has to look at the bigger picture here, quite frankly. Regrettably, I can't go into detail on the specifics of the 7 legs, who is linked to what. People are innocent until proven guilty. And it's not my responsibility to come and sit before this joint portfolio committee, or to publicly say, so-and-so is a suspect in this matter. I think it's inappropriate at this stage, to say the least. Who made the final decision in respect of the warrants? Well, I think that's a question that Advocate Governor will have to respond to. I was merely briefed on these issues, and I think General Matakata was also briefed on these issues. So I don't know whether General Matakata gave the go-ahead, whether Advocate Governor gave the go-ahead. I was merely briefed on the matter, on the matters. I don't know if you want to respond to that though immediately.
Can you address that so that we don't miss it?
Thank you, Chair and committee members. I think I want to start off by firstly saying that I think this notion that there is the NPA on the one side and the DPCI on the one side, in terms of what was happening in terms of the work that was in respect of this matter, must be dispelled. We work in a multi-agency approach, And as such, the investigation and the prosecution members sit together, go through what it is that there is in respect of this matter, give guidance, direction as to what is required, and based on that, the decisions are made and actions are taken. So with regard to the issues of the sufficiency of the evidence, ultimately that is the responsibility of the NPA to pronounce upon, but in pronouncing upon that, guidance would be given to the investigating officers as to how it is that those gaps need to be addressed. And I think it's important to note this process because it seems to be, there's an impression that seems to be created that the NPA is doing things in isolation of the investigation team, which is not the position, or vice versa. What had happened with regard to these issues of the warrants and the issues of the final decisions with the warrants, these were joint decisions that were made. Joint decisions that were made as to whether or not there was sufficient evidence in order for us to proceed, why there was not sufficient evidence to proceed, what it is that would be required in order to give that sufficient evidence. That decision was made by investigators and prosecutors. It was communicated to us. When it was communicated to us that there were certain reservations, Brigadier Bassi and myself engaged directly to go and look at this matter and give direction to the team. Once we gave the direction to the team, they made the final decision on the signing off of these warrants, which were then applied for by the police. And I think it's important to also note what the process is. The process is that a police official will give us a J50 together with an affidavit. That affidavit would have to set out what the prima facie case is, and in setting out what the prima facie case is, would also set out what those grounds to establish what the flight risk is. Now, one of the reasons why we wanted this is we've had instances where magistrates have come back to us and based on case law told us that they're not prepared to sign off on a J50 unless the state can show them that there is, in fact, when I talk about the state, I'm talking jointly about both the investigation and the prosecution, that we can show that arrest is required in these circumstances. So it was our view as a team, or it was informed to me by the team, and this information was also something that both Brigadier Bassi and myself agreed to, that these arrest warrants needed to ensure that all these factors took into account that in order for us to ensure that when we took the matter to a magistrate did not come back to us and say, no, I'm not signing off on these warrants. The next step is if we nevertheless proceed with an arrest in those circumstances where a magistrate signs off without those warrants, we still have, or the police, let me say, questions start getting asked. You must understand every single piece of evidence that there is in this matter is in fact placed in the A clip of the docket, and it comes under scrutiny at some stage by the defense. We have to disclose that type of information. So that's a conspect within which these joint decisions were made. So the prosecutors then get these arrest warrants, they give their advice to the investigating officers. Based on that, the drafting occurs. We have to satisfy ourselves that we are able to show from the evidence in the matter that we can each of the allegations that are put into that warrant can be justified by way of the evidence. So that process did take some time. But that process was being dealt with jointly. It was not being dealt with in isolation of the two teams. They were working together, and I think the timelines that were explained show how it is that that work actually occurred. So the final decision, it was the prosecution and investigation team jointly that made that decision.
It gets worrying when you talk about this prima facie case. Honorable Mlauzi spoke about where there's reasonable suspicion, you arrest. I thought the prima facie case applies at the close of the state case. So maybe at some other point you'll explain to us why the police wants to establish a prima facie case when the matter has not even come before the court. Honorable Advocate Sean.
Thank you, Chairperson. I'm going to jump further because I've dealt with the issue of the extradition, as well as that raised by Ms. Matopo. So a further question was raised around what is happening in respect of the other 7 legs. Well, the other 7 legs are also the subject of investigation. Of course, at what stages we are in respect of these investigations, the only people that can comment on that is, of course, the prosecuting and investigating teams. I do think there's some progress that is being made insofar as what I have been briefed on, and there are steps in the right direction to bring these matters to finality soonest. I'm deliberately not going into the facts or merits of the matters. I've discussed that with General Matakata as well. The leaking of information, that's always a problem. What we've learned over the last few years, and in fact the leaking of information in the NPA in particular stems back from the creation of the NPA. And that is a problem. That was a problem back then, and in certain instances it is difficult to contain that, because there are people within the institution that would leak information to members of the public, members of the media, to politicians, and in 99% of those instances it's misinformation. People latch onto this, and of course they try to create furores around particular issues. But I can assure you that in 99% of the instances it's misinformation, and it's from people who want to appear to be relevant. Insofar as leaking of information in the state of capture matter is concerned, we had a long discussion around that, and the prosecuting team itself had been isolated. Everybody wanted to know who's the prosecuting team. And these are senior members of the institution, leaders of the institution, DPPs, special directors, some deputy national directors wanted to know who are the members of the team. And we decided to isolate the members that are prosecuting this matter. It's on a need-to-know basis. And that's how we actually curtailed the leaking of the information. And I don't think any information has been leaked from the prosecuting team that I am aware of. Yeah, or the investigating team. Let me add that. I think the issue around case problem solving in respect of this particular matter, my understanding from the briefings that I received was that there was such a good relationship between the prosecutors and the investigators that if there were disputes, that these disputes were resolved internally through their own internal mechanisms. If issues had to be escalated to myself or to General Matakata, we would of course address those issues between each other, and that would then of course evolve downwards with instructions or directions or feedback being given either from my side or from General Matakata on issues that were in dispute. How do we deal with the issue of perceived selective prosecutions? What many people don't understand is the structure of the NPA. Everybody thinks that the national director makes decisions to prosecute. There are thousands of cases that are on the court rolls on a daily basis. Do you really think that I make all those decisions? There's a very small percentage where I have made decisions in respect of matters. And those would only apply where I have reviewed those decisions or where policy directives had not been adhered to. So I have 4 deputy national directors who derive their powers through the national director. We then have 11 directors of public prosecutions who have original powers to decide on matters that fall within their area of jurisdiction. So each and every prosecution that takes place in a province is taken under auspices and in the name of the Director of Public Prosecutions for that province. Similarly, with regard to special directors.
I think spare us, not give us a lecture on that. I think people who are speaking about selective prosecution, are specific. They think that we target junior people or people that are flying, and then we are not dealing with the big shots. So if you can just address these matters, the perception that the big shots are not being arrested, the processes I think members would be aware of.
With respect, Honourable Chairperson, I think it's important for the public and for some members of the committee that do not understand this process to understand how the structures of the NPA work and where decisions are made, because the perception out there is that the National Director makes all the decisions. If there's a non-prosecution in respect of a matter, it is the National Director who is not prosecuted. If there is a prosecution in respect of a matter, it is the National Director who has instituted that prosecution.
Chairperson, you see, the head of NPA must be reminded that he's the head of the NPA there, not here. Here, this is Parliament. This is Parliament. Thanks, Chair.
So just not lectures on the process. Take as a given that we all understand. And then on our appeal that those who don't understand, raise your hands and say you don't understand. Just go straight to the question of selective prosecution. Is there selective prosecution or not?
Thank you, Chairperson. I disagree that there are selective prosecutions. The directors of public prosecutions who make decisions to prosecute do so independently of the National Director. I am briefed in respect of these matters. I will intervene if I need to review these matters, or if policy directives have not been adhered to.
Yeah, no, a point of order, Chairperson. No, we are talking to the head of NPA Amos. Does it mean that he is just jolling up there, then he's not controlling those public prosecutors down there? They are doing as they like. Let's not allow this thing, Mos.
Honorable Bisongo, point noted. I think we have pointed that out. Let him proceed. Thank you for.
Thank you. And of course, I am briefed. I am briefed on high-profile matters. And if I'm made aware of particular matters, I call for briefings. So I would disagree that there's selective prosecutions, but I'd be the first to concede that we can do more. We can do more, and we're striving to do more. And we're striving to do so by working closely with our stakeholders to bring matters to justice. With regards to the Scopa report, I definitely will revisit the Scopa report. I'll have a look at the 100 cases or so that are referred to in the Scopa report. And I'm not in a position to comment on that today. The question on whether, well, the statement was made that there's an impression that's been formed that is a fragmented approach to the relationship between the Hawks and the DPCI, the Hawks and the NPA. These matters are investigated under prosecutor-guided investigation methodology. And this places reciprocal responsibilities on both the prosecuting teams and the investigating teams, and they're compelled to work together. And as Advocate Govender explained earlier on, the teams were working closely at all times. And it was not a matter of the prosecutors sitting back and the investigators doing all the work. It was a joint initiative and efforts and endeavors by the investigating and the prosecuting teams. And that's part of the SECU methodology.
Yeah, thank you for that response. Yeah, I'm listening attentively to the input, I think Advocate Governor also sketched good cooperation, excellent cooperation. The team sit together. But Advocate Abrams, if I analyze your presentation this morning, especially on the timelines in terms of the Estina project, if that was their close cooperation, why was there additional information, financial reports asked at the end of the process and not during the process? Because that dispels, in effect, this close cooperation that you attest to today.
Also, I don't think that the members are more interested in cooperation and things like that. They want to know why there's no action where even ordinary people in the public think that action should have been taken, especially against politicians or senior people, and that's what people want to know. And if we could hear that rather than debate close cooperation or non-cooperation.
I think with regards to the challenges that arose between the investigating and prosecuting teams, these are issues that ordinarily arise during the course of any investigation where people agree and or disagree as to what is required, when it is required, and ultimately how that is processed eventually and how it impacts on the administration of justice. I think the best people to comment on how those challenges came about and why there was no agreement, as you would have expected there would be agreement, would of course be the lead prosecutor and the lead investigator. They would be best placed to explain that degree of inconsistency and how it came about. With regards to the issue of, and I'm not even looking at the questions now, I just want to respond directly to the issue raised by Mr. Mutsecha. Your question is, why have no politicians, been arrested or charged in respect of this matter? This is a matter that's still the subject of investigation. The matter has been postponed until August 2018. That does not mean that there will be no other arrests. The matter is still the subject of investigation. And to publicly say Mr. X or Miss Y will be the subject of an arrest or an arrest warrant or will be charged in respect of this matter, I think it's inappropriate. Please, I implore on everybody, allow the investigative processes, to take place. It doesn't matter how anybody here or anybody out there or I feel about anybody. We need to treat people fairly. That's what the Constitution says. So the matter is still the subject of investigation, and if the investigation ultimately warrants that more people must be added as an accused persons or be charged separately, then that process will take place.
That give us names of politicians to be accepted. We are saying the perceptions are that we are targeting junior people, subordinates, and nothing is being said or done about everybody. So it's for you to explain that investigations are going on and investigations affect everybody regardless of their standing in society. So we have to explain that so that society doesn't get the perception that there is selective prosecution. That's all we're saying.
Thank you, Chairperson. I accept that, and that's why I've made the submission that I have. That the matter is the subject of investigation, if the investigations lead to other people having to be charged, then they will be charged. Nobody against whom there is a prima facie case, and where the interest of justice dictates that a prosecution must be instituted, will be let off the hook in respect of this matter. This is a discussion that we've had before with Advocate Governor and the prosecuting team, and I want to re-emphasize it here that nobody will escape justice in respect of this matter or any other matter. Thank you.
Not a point of order, Chair. It was just a follow-up on this question, if I may. With respect, and I accept that you can't go into detail, Advocate, but the explanation that you give, perhaps this is not only for you, it may well be for DPCI as well. If you look at the case under discussion, so your explanation in terms of selection of those that must be prosecuted at a category 1, if you like, and others will be category 2, are you suggesting that their crime activities was exclusive of those who are in the position of authority? Because I mean, if you're investigating a meth house farm, you would have officials, you'll have also the non-officials who are in a position of authority who would have given a decision that this and X must be done. So what you don't explain is the fact that in that investigation you have selected that you will deal with this group A and you have left the group B for the later investigation, because it's intertwined. That particular crime is intertwined activity. How do you manage to sift through that to isolate those who are junior and leave the seniors? This is not only your question, it's a question also DPCI as well. That's just a follow-up, because my difficulty understanding this, it's explanation that takes so long that does not even deal with the questions that we're asking.
I think it's a very fair follow-up. Both of you, can you address that these intertwined issues? How do you then create categories that will deal with category A, arrest category A, and then there will be arrest of category B? And
thank you. I'm pleased that you raised this question. Let me first say that there are many investigations in which one does draw that, that analogy of a category A, a category B, a category C, etc., etc., and and as part of your prosecution strategy and your investigating strategy in dealing with a particular matter. This is not the case in this instance. In this instance, the people that have been charged, there were prima facie case against them. Now, for us to charge any other persons requires further evidence. Now, if there's no evidence, prima facie evidence against particular individuals at this stage, and you directed further investigations, and that further investigations ultimately will decide whether persons must be charged or not. Have I answered your question? Thank you.
The question is directed no. The answer is no.
That's the furthest I can take in respect of this particular matter. I regrettably cannot, go much further than what I have. Otherwise, I would be divulging critical information around this particular investigation that should not be divulged in public or in Parliament or elsewhere until such time the criminal justice process has run its course. Thanks.
In reference to a certain Manele, who made an accusation that got instructions that certain politicians should not be arrested, and that you or Mrs. Matakane obliged. Can you remember it?
Yes, I've made notes of all the question. You are the question related to to Knox Molele at Asset Forfeiture Unit. Asset Forfeiture Unit does not have the powers to affect arrests. So I hope that answers the question. Thank you. There was the question about everybody put ice, or everybody stopped, so-called stopped work in December 2018, or they put everything on hold. And of course it was followed up by, did anybody wait until 20 December, 2017? The work in this matter has always been ongoing. We obtained a preservation order long before the Christmas break. We obtained a preservation order of 1.6 billion in respect of the McKinsey matter. So if our work had stopped at the time, we would of course not have proceeded, with the preservation order. My understanding from, the Estina matter, for which we obtained a preservation order in January, was that a date was obtained during the second half of January. So to say anything else, I think, would be scurrilous under the circumstances. So the work still continued. As to the investigators and some prosecutors going on leave, that's something that that the lead investigator and the lead prosecutor will have to respond to. There was a question wanting to know what is still outstanding in respect of the Estina matter. I with respect don't think it's proper, for would-be suspects, or accused persons who have already appeared before court, or the public, for me to sit here in front of Parliament where the whole country is watching me, listing what is outstanding in respect of, of the Estina investigation. It flies in the face of the proper administration of justice. And there's many court decisions where the court said it's undesirable for accused persons or anybody else to peep over the shoulders of investigating authorities during the course and process of investigations. Whether Advocate Govender had consulted with the Director of Public Prosecutions in terms of Section 24(3), she will respond to that. There was a question about what informed the issuing of the warrant of arrest. I'm not sure if she's dealt with it, but she'll deal with it. Okay. Is it correct, there's a question directed to me, whether I deliberately withheld on a particular matter. I did not withhold on any matter. In fact, my direction and instruction was clearly, that these are matters that need to be dealt with as expeditiously as possible. I disagree with the statement that this was a bungled investigation and a delay by the NPA. I've addressed that issue earlier on. Sorry, there were many questions that were asked, and I'm just trying to see which ones are relevant to me. There was a question around, is it incorrect for the NPA to utilize the provisions of Section 43 of the Criminal Procedure Act, which relates to arrest? You know, we've never intimated at any stage that it's our prerogative, you know, to issue directives for arrests to be effected. We accept that it's the legal and constitutional responsibility of the police to effect arrests in any given matters. But when you're working as a joint team and decisions are being taken and there's particular methodologies that are utilized, then the relationship is such where there's a consultative process and a concurrence process with regards to what has to transpire, when it has to transpire, etc. The reality is, whereas it's the police powers to effect arrests, it's the prosecution's prerogative as to what charges need to be preferred and whether those charges would actually stick or stand at the end of the day, or whether the evidence substantiates the charges that a particular person has been arrested for. I think all the matters that the EFF have complained about, I'd be very pleased if those matters can be brought to my attention and I can inquire from the relevant officers as to what has transpired in respect of these matters. I did not rush to charge Ms. Breitenbach nor Minister Godaan. I did not make any of those decisions. That was a statement that was made earlier on. And I'm happy to go into the merits of these or into into the whole decisions. I don't think it's necessary for purposes of this engagement. I'm not, of course, we did submit letters of request for mutual legal assistance. The Director General of Justice is the central authority for the Republic of South Africa, through whom requests for mutual legal assistance are of course channeled through DIRCO, through the international process to our foreign counterparts. So these are the engagements with DIRCO, of course there's engagements with Justice, and I'm not sure if there has been engagements with the Department of International Relations and Cooperation, but ordinarily, in big matters, there is engagements with, with our missions at the various countries, as well as with our foreign counterparts. There's direct engagement on these issues. And in this instance, there has been direct engagements with at least 7 prosecution services of the 8 countries to which requests for mutual legal assistance have been submitted. As to the timeline of the investigations, there's still the matter's postponed until the middle of August. So the investigations has to be concluded way before then. And and with regards to the investigation in the rest of the state of capture matters, of course the lead prosecutor and the lead investigators are best to be able to give more clarity on that. We, of course, would like these matters to be investigated as speedily as possible. A direct statement was made to me that I delayed arrests. I did not delay any arrests. I don't make the decisions as to who should be arrested or who should not be arrested. This is part of the misinformation and narrative that's been put out there, which is completely incorrect. There's a statement about the NPA being politically captured. That is completely incorrect. Now, again, I just want to contextualize that, if I may. There are plus minus 22 to 23 presidential appointments. The national director, 4 deputy national directors, 11 directors of public prosecutions, and plus minus another 5 or 6 special directors of public prosecutions. Now, most of the people, or the majority of prosecutors in the NPA, are career prosecutors. Now, for anybody to say that the NPA is politically captured, they'll have to be more specific and provide direct evidence and say, so-and-so is captured, and these are the reasons why, and by whom. I think to say that the NPA as an institution is politically captured is, with respect, a completely irresponsible statement to make. There are hard-working prosecutors out there who make many sacrifices throughout their lives to deliver justice to the community. I personally was a career prosecutor who made many sacrifices, and there are many people like me in the institution that have given their lives to serve and provide the best criminal justice service to the citizens of this country. I've addressed the issue around the question of November, December. The issue of the plundering of the land in KwaZulu-Natal, I'd be happy if those matters are brought to our attention to have a look at. We'll also look into the Glencore matter. Why did we not bring Knox Molele? We looked at the reasons as to why we should be here, and there was no need to bring him here. There's no sinister reason as to why he's not here. He cannot speak about asset forfeiture matters, prospective asset forfeiture matters, and the reason why we are here is directly as a result of what happened last week. The question around IPID, allegation of selective prosecutions, as IPID had purportedly alluded to. Of course, IPID has submitted a number of matters to the NPA. In some instances, we've decided to prosecute. In other instances, we've decided to decline to prosecute. IPID has not happy with matters in which we decided to decline to prosecute. The reality is, not because a matter is submitted to the NPA, does that mean automatically there must be a prosecution? It doesn't matter whether it's the police detectives, the local detectives, or the head office, whether it's the Hawks, whether it's IPID, whether it's crime intelligence. It doesn't matter who it is that submits a matter to the NPA. Investigators may genuinely believe there's a basis for a prosecution. And prosecutors perusing the matter may be of a different view that the evidence in that docket would not be sustainable to obtain a conviction. And of course, there are also instances where the interest of justice does not dictate that a prosecution should be pursued. So I think once again the perception that there is selective prosecution is completely incorrect. The issue of the operational committee, there are ongoing engagements between the Minister of Justice and the Minister of Police. Of course, there's now a new Minister of Police, and there's also been key discussions between the heads of various structures that fall under the administration of or area of responsibility of the Minister of Justice and Correctional Services, as well as the institutions under or the units under the Minister of Police, where there have been critical discussions, as to joint initiatives to enhance service delivery in the fight against crime. This is one of the issues. That I'm certain will be dealt with.
Those ministers should come here because you see, I get the sense that we're not getting to where we need to be getting to, because our concern was there appears not to be action. What could be the stumbling blocks? And we wanted to assist in the removal of the stumbling blocks. And bare denials are not going to assist us. And also, we cannot stop society from having perceptions. Society must have perceptions if they think that there's no movement going forward. But I don't know, Co-Chairperson, I just get the sense that we're not going anywhere, but I leave that to you to what you think we should do.
Yeah, I think maybe also to get a view from the floor, and then we can maybe look at the way forward. But it's going to be important listening to the input that maybe that the executive authority should be part of that discussion. Yeah. But let's hear the members.
If you are happy, Elder Bungu,
Thank you, Chairperson. Thank you, Chairperson. I think I agree. The route that we are taking, it's not bearing fruits for us, because the intention here was not to get into the operational issues either of NPA or DPCI. All we need to do is for them to have a good working relationship, and they have said they have that. And the perceptions that are there, whether correct or wrong, that's all we need. We need to deal with that, because otherwise, if the aim is not to tell you who to arrest and when, otherwise we will be doing the same thing that people perceive is happening. But all we need now is to get the assurance that some work is going to be done. And if there's some way in which we can get that assurance, I think all of us will be happy. Because there's no way in which we can say, go and arrest that one because he has got an ugly face or whatever. It's not up to us. As I said earlier on, we do oversight as the police over the hawks. And they account to us. And what they do, their performance measurement, is the cases that they take to court. And if they don't do that, they need to account to us. And if your measurements as the NPA is something else, then you need to do something about that. Because it makes, you can sit with the dockets and your performance measurement is not affected as the NPA, because that wouldn't be your measurement, your performance measurement. And that needs to be corrected. whilst the dockets are on you, whatever the reason might be, there's no action from the Hawks. That is our main concern. And if you can sort out that, then I think we will be satisfied as the Portfolio Committee on Police. So we are not throwing allegations. We are simply saying our side of the oversight is not performing, and we want to take that out so that they perform.
Yeah.
And if that can be sorted out, we are happy. Either you're going to sit down, both institutions or agencies, and sort out what your performance, because your performance indicators are affecting the Hawks' performance indicators. And it can't work that way, because according to us, they are not performing. Thank you, Chairperson.
Thank you, Chairperson. Greetings to honorable members, the leadership of NPA, Hawks, and everyone. Chair, I fully support what you have proposed. I'm of that view that we need the members of the executive, the ministers responsible for this department, to attend. Because I also have that sense, Chairperson, that really it seems that we are not going to reach the gist of what we want to reach as things are happening now. I therefore submit, Chairperson, that we will really need them as a responsible people on this department. You know, Chairperson, when these things comes out in the media there, it paints a very negative picture about the law enforcement agencies of our country. And it demands of us to really exercise our oversight role diligently and make sure that everyone who's accountable performs accordingly. It is for those reasons, Chairperson, that I support your submission that we need members of the executive so that we deal with these things once and for all with no doubts. Thank you, Chair.
No, Chair, I want to also agree. I mean, we still have to get the presentations as well, that the advocates ambush presentation this morning. We need to get a copy of that, and we need to get the responses from the DPCI. And then, of course, we need to get through, because we will need to get some other information. For an example, Chair, the advocate says we want the DPCI, in terms of the Act, to delegate us responsibility to do the investigation. But the multitask team, it is not making headway. They has backwards and forward in terms of it. The advocate says a guided prosecutional thing. It's not multidisciplinary team. We quite don't know what we're dealing with. It's a guided, multidisciplinary, which is integrated. Now, give us some powers in terms of the DPCI Act for us to do some of this investigation, then we will deliver. Now, I don't know if we can't deliver on the other, what will then be a magical to deliver exclusively when you are given the power? Maybe the minister will help us to understand some of those issues, because we are not getting answers. We're getting explanation, which put us in the same position we were when we arrived here, frankly. Thank you, Chair.
Thank you, Chair. Very strange calling you Chair, but thank you. To both chairs, I agree with my colleagues here. I think the only way forward, and the only way we can possibly start delving down to where we should be, is to bring in the ministers and the former Minister of Police to answer to allegations that have been made. Let's clear that up once and for all. get the answers to our questions. And I must say, at no stage has anyone in this room asked for details of any investigations, and yet we face great defensiveness in this regard, manufactured, I presume. So this entity as a whole has, according to what I've heard, and I think we've all heard, has failed at this investigation thus far. We're now hearing even excuses about extraditions, number one, that shouldn't have to be taking place because they knew full well they were flight risk, and of course they can be charged for anything. So really we need the people at the top to come and give us answers. So I absolutely concur.
It's another view. I think that when we came here, we wanted to identify stumbling blocks, obstacles, and help to remove them so that the DPSI and NPA can go and ensure that there is action that is credible. And the only stumbling block that we have dealt with is that you are able to work together. We are happy with that. But still the feeling is that we are not getting anywhere. And I think also it would be fair that we get a response to your presentation from Advocate Ramatagane, if you prepare that, and then we then approach the Minister of Justice, former Minister of the Police, and the new Minister of the Police, ask them to appear before us together with yourselves, and hope that from the questions that you had, you can also refine some of the answers that you gave us, because we are not representing ourselves, we are representing society, and we may accuse society of having perceptions, but these perceptions may be as a result of the perceived lack of action. So I think that ourselves as members of parliament, we will be not doing our work if we don't work in such a way that unnecessary perceptions don't arise. We have to do our work in such a way that society to which we account is satisfied that we are delivering, to borrow the words of Honorable Mahake, that society wants performance, wants us to perform. And therefore we also want to see performance from your side, and the only way to move forward without trying to ask you to step in your shoes, I think let's agree that we'll agree with my co-chair and the two committees that we'll get another date. We'll invite the two ministers, including the former minister of police, and then we take this process forward. Honorable Mlauzi and Honorable Songo, did you want to say something?
Yeah, thanks, Chairperson. I heard you were listing the number of the people to be invited to be, maybe to be part of our meeting next time. I'm thinking also we must also ask Advocate Mulele also to come, and the regional NPA representative of Free State and of Gauteng, so that you can get clarity, as you said, about the regional leader of NPA in Western Cape. How about the direct people?
Yeah, no, I wanted to make a recommendation on top of what my colleague has raised. Chairperson, with your respect, we know that here in Parliament, various committees looking into state capture have been formed, and serious matters have transpired there. If maybe comprehensive report can also be sourced from these committees, so that these structures can tell us what are they doing, or they just watch televisions and then say, hooray.
Must prepare, and in preparing we can source information from elsewhere. But I think for the purpose of now, we agree that we need a further meeting with yourselves and the other interested parties that we have agreed on. Co-Chair?
Thank you, Chair. I think one practical issue that maybe both entities can look at, and maybe not in more detail, but the issue of the coordinating committee. Because I think if that issue is dealt with comprehensively, a lot of the issues that's on the table today and that occurred last year could have been averted. So I think that is quite important. Maybe the executive authority should also be requested that the necessary attention is given to the coordinating committee in terms of the SABC Act. Thank you.
End of this meeting, but thank you very much. I think we may also have ambushed you because you may have thought that we have come to account in the normal way, but this was an exceptional meeting. Thank you very much. You are well excused.
Sean Abrams being confronted by MPs in a joint sitting of the Police and Justice Committees. It was certainly an interesting morning listening into that briefing. From somewhat of a standoff between Sean Abrams and the acting Hawks head Yolisa Matakata, and allegations from Matakata that the NPA sat on the Estina dairy docket from November until February before giving the go-ahead for those arrests. Also, clearly visibly irritated MPs, beyond annoyed at what they call the record of inaction by state organs when acting on criminals in cases of corruption. And this, they say, can be traced to the highest office under the former president. So really, in that briefing, the independence of the NPA under question there. MPs questioning Sean Abrams' allowance of political interference, which he has denied, especially when it comes to the Estina dairy farm component of state capture. Abraham said that he doesn't know of any matter where there's been sabotage in respect of an investigation. So that just in short some of what came out of that briefing. But at the same time, the Eskom inquiry has resumed. That's also underway. We know that Dr. Ben Ngubane is at that briefing in Parliament. He's testifying before the board, and of course this is the second appearance of Ben Ngubane before that parliamentary inquiry, following that of the inquiry into the SABC, which was probing the fitness of the Public Broadcasters Board to hold office. Ngubane was the chairperson of the board at the time. He also sought to clarify the employment contract of ousted Eskom CEO Brian Molefe. He was also asked about a PNG meeting that led to the internal disciplinary proceedings of the former Eskom executive Matsela Koko.
There were a couple of issues touching upon the recruitment process and other PNG issues. However, I brought to that meeting a document that I had found on my desk, which was not dated, not signed, putting certain allegations about Mr. Matsela Koko. I gave this to the board members, and we came to the conclusion that we had to give this document to Mr. Koko and ask him to respond by end of the working day to what was raised. The statement was duly given to Mr. Koko. Somewhere in the afternoon, before the scheduled meeting, he came to me and said, well, of course, this timing was not sufficient. But he also told me that he was facing a lot of difficulty as acting group chief executive because he was moving people around at Medupi and Kusile because of certain serious issues. He didn't go much into the issues, but he mentioned things like fictitious companies were being created and funded. But he was handling this as a group chief executive together with ESCOM Security. And then I went back to my colleagues. When we came to the meeting at about 6, I think, the intention was to suspend Mr. Koko and institute an inquiry. But in our discussions, it emerged that actually we needed to give him 48 hours for a response before you can suspend a person. And of course, the issue that there was no name to the document raised the issue of this being not a grievance letter, but a whistleblower document. Now, I was reminded that ESCOM policy requires whistleblowers to be dealt with through the Audit and Risk Committee and through the Assurance and Forensic Division of Internal Audit. We then took a decision to submit this document to the Audit and Risk Committee, who subsequently dealt with it through Assurance and Forensic, and this led to the inquiry that eventually took place.
Former ESCOM board chairperson there, Dr. Ben Ngubane, giving evidence